থাকবে। উঁচু করবেন। Yes, please.
One is the withdrawal and one is the inclusion in the list is filed on the
Inclusion of list of what? Under what heading? Matter. Yes, very well. And withdrawal right to be mentioned for withdrawal. Right to be mentioned within bracket for withdrawal. Yes.
May I mention, ma'am? One miscellaneous first appeal against the rejection of the claim.
It has not been admitted yet.
No, no.
Yes. It will appear on order for turn.
Another title appeal, paper book has been completed. 5 minutes will be required. 5 minutes. It's 6 minutes is then matter will be different.
No, no.
Paper book is ready.
What is the point involved?
Only challenging the final decree and the commissioner. Preliminary decree not challenged.
No, no further addition. There are already several appeals. Let us hear. No.
5 minutes.
We have refused others yesterday. No. Sorry.
Monday to
No, no, no. Next week you won't be able to complete. No.
Please, my lord.
mention one matter for arbitration matter. Item number 68 that this is a legal aid matter, my lord. My lord, 10-year punishment was given, my lord, already 8 years he has completed.
It's already appearing. No.
68, my lord, for arbitration.
Lordship has can recall, yesterday Lordship has fixed 2 matters for Monday. Final hearing.
No, then we'll keep it on. Keep it tomorrow then.
Yes.
Tomorrow.
Yes.
Please inform the other side
Yes.
because they also have to come prepared. Yes.
My lord, may be permitted to mention one item. My lord.
Yes, but
My lord, yesterday one item was mentioned, filing number MAT of 40 of 2026. It was
yes, yes, yes.
directed to be listed today under the heading to be mentioned.
ওটা আসেনি? Please check with the office. We have directed the office to give a number and show it as defective. Mention with the new number.
My lord, actually the defect
সোমবার
was
আসবে? আসবে তো? আমি জানি ওটা আমি কথা বলেছি ওদের ডেকে বলেছি যে ওটা ফাইলিং নাম্বার দিয়ে ডিফেক্টিভ দেখিয়ে দিতে। It will appear on Monday.
Yes, sir.
I've had a talk with the office. Yes.
Item number 1.
কি জন্য অ্যাপিয়ার করছে জানেন? Written notes আছে। Oh, that matter. Yes. Please file your
Item number 1, Lordship.
file your
For the
written notes.
petitioner, Lordship. I am led by Mr. Bikram.
Yes.
Written album, 3 pages, never restricted.
Thank you very much for making it short. Yes.
This is much more.
High court will be shorter. Yes.
Lordship,
Please. Thank you.
If I get 1 minute.
Yes.
The question is, Lordship, before us, regarding my part, the consultation part of the High Court, whether the Chief Justice,
Under which provision?
Chief Justice alone or
Yes, yes, yes. We know.
from section 7 of CRPC is there.
Section.
CRPC the Barcon section 7.
Yes, section 7 you have mentioned in your notes. Yes,
Lordship, now, apart from that, kindly appreciate one point, that is section 56. Lordship, the acts which as per the notification, there are 2 special acts and other acts are general acts. So regarding the general acts, the CRPC will be there, but in a special act, Lordship, kindly consider section 36
Of BNSS?
NDPS Act, because NDPS was there.
Ah.
Constitution of special courts. The government may, for the purpose of providing speedy trial of the offence under this act by notification in the official gazette,
Yes.
constitute as many special courts as may be necessary for such area.
You have
or
cited
area.
section 36 of NDPS and section 43 of PMLA.
Same
Good.
thing.
For these 2 acts, so that's
The
permissible.
consultation with the Chief Justice of
Understood. So that's permissible for this these 2 acts.
these 2 acts.
Regarding the other 2 acts, your general
General
argument.
section 7 said.
Good.
Grateful, sir.
Fair enough.
But also one indulgence, that is PMLA, the notification should be given by the central government.
Yes.
This is central government.
Yes, that is there. The state has a very limited role to play there in PMLA acts. No?
The notification in the official gazette, but it's central government. And consultation with the Chief Justice. The Chief Justice.
So Chief Justice has been considered but by the state government.
The head of the roster amounts to, so if we take 2 simultaneously, consultation of the Chief Justice amounts to consultation of the High Court.
Unless Mishra submits that the central government and the state government are the same.
I said, my lord, that the Chief Justice and the Supreme Court are never wrong, and I still abide by that.
Until proved wrong.
Until proved wrong. There is a presumption in law.
Well, well. Thank you very much. All of you, thank you very much for the precise notes and for taking the trouble. Thank you. Written notes of arguments filed by all sides today be kept on record. Hearing is concluded and the matter is reserved for judgment. What is it? Thank you.
Item number 2.
Why? Well, on the prayer of the appellants, the matter is adjourned till June 15, 2026. But try not to take adjournments in these matters because the difficulty is state is hard pressed with few people. So they can only prepare themselves in limited matters. And when those matters come up and if you take time, then it pulls on the resources. I mean, they cannot be ready in other matters. That's why when they come prepared in a matter, for this this teething period, please don't take adjournments. The petitioner appellant don't take adjournments. We are trying to convince Mr. Mishra for you only, for the petitioners and the appellants. They come prepared. They're very hard pressed otherwise. So if they come prepared in a matter, if you don't do the matter, another matter will suffer because they could not prepare themselves in that matter. So you come prepared if Mr. Bhumik is not there on the next day. Next matter, please.
Item number 3.
Monday.
Yes, Mr. Shah. You never ask for adjournments. Good of you. No, you never do. Yes.
Not
You
in this
prepared
matter,
us.
Lords, only the CRAN application is there with us.
CRAN, yes.
The appeal is not.
Appeal pillar. Yes, what is the matter? Tell us.
Based on circumstances. You are. The complaint is the brother of the deceased who lost a complaint on the 12th of October 2019, saying that his elder brother Bangla Kodap was went to a mountain road in pipeline and thereafter
Give the microphone a bit closer to.
His dead body, one dead body was discovered
Thank you.
and the local people witnessed it and they had communicated to the de facto complainant and de facto complainant come and see that the dead body was lying thereat and he cited also that on 12th of October 2019, Baldev Lohar, that is the appellant here, Sundari was roaming around at Sundari Bosti area and he came to know that Baldev Lohar has murdered his brother. This is the initial affair. Now,
No,
Baldev Lohar,
complainant was one of the brothers. There are three brothers.
no, the complainant is the brother of the deceased.
Brother of the deceased.
Deceased. Now, on after lodging of the affair, the appellant was arrested within 2 days on 14th of October 2019. Thereafter, charge sheet was submitted. However, the prosecution has relied upon as many as 18 witnesses. The 18 witnesses. The best piece of witness is PW11, who has recorded his 164 statement. Now,
He was an
according to-
eyewitness.
eyewitness. No, not purported eyewitness, but they have claimed that they are eyewitness. Now, 164 statement has been recorded. This is the best piece of evidence of the according to the prosecution story. Now, Lordship, I'm reading out the 164 statement.
Yeah. 111.
The PW11 who recorded his statement under 164, he stated that on 11th of
If you have a
previous-
copy, why didn't you annex it? You have annexed it.
164. But
Huh?
it is written.
So you have a
Yes.
copy, you could have annexed.
No, we have a copy.
We have copy.
Whatever copies you have, you annex to the bail application so that the other side can also look into it and we can also. It's easier for us. Handing over one copy would not help you because there are two judges here.
2 copies আছে।
Yes, the two copies are there.
164. 164.
It is in Hindi.
It is written in Hindi.
All these things, if you want to rely on, just annex small, not very thick. So annex it to the.
Should be.
Anyway, whatever. Yes.
So I'm reading out in English, a translated copy. on 11th of previous
You can
month.
also read the Hindi one. No,
Sorry.
May I read?
yes, yes, read it.
पिछले महीने का 11 तारीख बलदेव मेरा घर से
घर में आया।
आया
घर
और
में आया।
मेरा कुकड़ी मांगा और बोला कि पोल्ट्री मुर्गी काटने के लिए वह कुकड़ी उनको चाहिए। मैं उनको मेरा कुकड़ी दिया। उसके एक दिन बाद बलदेव मेरा कुकड़ी लौटा दिया। उसके एक दिन बाद पुलिस मेरे घर में आया और मुझसे कुकड़ी के बारे में पूछा जो मैंने
मैं और कुछ नहीं जानता हूँ, is very important. Very good. Read it. Yes.
Now, there is now according to that statement, the offending weapons was borrowed or taken away on 11th of October 2019. Now that same weapons was returned to that particular PW 11 on 12th of October 2019. Now the seizure of the offending weapons made on 13th of October 2019 according to the 164 statement. But thing is this, that which does not correspond with the prosecution case, because admittedly the seizure list of the offending weapons was made on 15th of October 2019. Now more so,
No, 13th, where do you get that 13th date?
13th lawship, it has been stated by the PW 14.
No, 164 तो बोल
So 164, in the 164 statement it has been stated,
after 1 day.
after 1 day it has been returned.
Who is PW 14? This
PW
is PW 11.
No, 11. PW 14 is, sorry, PW 13. PW 13 is a Molvi, is a father-in-law of the appellant. Father-in-law of the appellant,
So what is the importance of his witness regarding
because there
seizure?
is a discrepancy.
He might not know, but the seizure list will show when it was
Definitely. Seizure list on
15th.
Seizure list dated 15th of October.
15th, yes.
Yes. Now,
Whatever the father-in-law says when it was seized, that's unimportant.
Proceed. Now, according to the prosecution version, there are 4 date of occurrence. Date of occurrence. That is the trial court was pleased to hold that the date of occurrence on 12th of October 2019, whereas PW 14 he stated that it is the date of occurrence is 10th of October 2019, whereas the PW 11 has stated that date of occurrence is 11th of October 2019, whereas PW 13 also stated that near the time of 8th of October 2019, the occurrence has allegedly
October?
8th of October 2019.
Near the time.
So 4 witnesses cited different date of
Who
occurrence.
was P30? PW 13 was the father-in-law.
No, 13, no, not 14. PW 14 stated that 10th
14 stated 10th.
10th.
14 is father-in-law.
14th is, no, 14th brother-in-law of the appellant.
Brother-in-law.
Of the appellant.
13 is father-in-law.
13th, no, 13th is
Yes, 13 you said. is-
father-in-law of
Father-in-law.
the appellant.
And PW 11 is a third party who is a
Yes,
purport right
he is
witness.
a Caesar witness as well as the.
What is he? He was a neighbor or he was passing by? As per the prosecution case?
as per the-
PW 11.
He was the one who gave the cookery.
Who gave the cookery?
Oh, the
Who gave
right,
the
right,
cookery
right,
and
right,
returned it? Got returned it.
right.
Now, de facto complainant, the PW2, who also stated that as per his information, the occurrence was on 12th of October 2019. Now, the cause of action or cause of date of occurrence is diverse. Now, the first. Second thing, that the trial court was pleased to hold the appellant solely guilty.
PW 11 does not say 11th of October.
No,
He says it was taken on 11th of October, returned on 12th.
No, in the cross-examination, PW 11,
Achha.
cross-examination. In the cross-examination, it has been categorically
Very
stated
well,
that on 11th of October 2019, Baldev Lohar asked for cookery from
Mr.
me.
Shah, don't make it an appeal hearing, just the
Sorry,
main
sorry,
points.
sorry.
Yes. Most important points.
Now that the learned trial court was solely relied upon the sole theory of a last seen together to hold guilty the appellant. The learned trial court that since according to the FIR, I was allegedly shown as was roaming around at that point of time. That's why I have
You were
been,
last seen together with the victim or
Yes,
roaming
victim.
around seen together with the
Yes.
victim.
according to the FIR. Now kindly see this the PW10, who is the deposition of PW10, who is the independent witness. PW10. PW10 has categorically stated no. Lordship, it is a very important paragraph. I am just reading out. On 12th of October 2019, I was at home. It was the time of Dasera Tika. guest had come to my house for tika. Baldev and Babulal is the deceased. Baldev and Babulal came to my house and they asked for liquor, worth of rupees 100, and thereafter they left my house and they went to the house of S. Jigri. They left for, I'm harping upon this particular thing, that we went to the house of, they went to the house of S. Jigri. I do not know what happened thereafter. Even assuming PW 310 is 10, it has seen that appellant and deceased together, the doctrine of last seen together does not hold any water, because PW 10 categorically stated that both of them thereafter went to the house of another individual, that is S. Jigri. Thereby, the last seen together theory does not hold the water. This is the one thing. Second thing is this: that particular offending weapons that was seized and it was sent for RFSL report, FSL report, but the report has never brought on the record. It has been categorically admitted by the IO investigating officer.
The weapon.
That is PW 17.
Weapon. FSL report never came. It was
No.
not produced.
No, never.
All right.
I did not collect any fingerprint.
I did not collect anything, any fingerprint of the offending weapons. Fingerprint of the
Weapon
offending
was produced, but
weapon was
FSL
produced,
report was
fingerprint,
not.
no. Fingerprint report
Very,
was not
very,
produced.
very.
Now, there is no conclusive chain indicating that petitioner, the appellant, is the sole person who has committed the murder. This is my sole argument.
Even if you solely did not commit the murder,
no,
then
definitely, but there is no cleansing evidence that anybody that I have seen did, because the sole last seen together theory is being watered down, because that one S. Jigri is there according to PW 10. He is an independent witness even.
Jigri gave evidence.
No, this is the very crucial thing. His
But you
evidence
could
was
have
withheld.
demolished this by producing Jigri.
Jigri, this is his statement.
You could have produced Jigri to demolish this, because Jigri, he said that he left his house and went to someone else's house. He never saw him. He never accompanied. It's not his case that he accompanied them to Jigri's house.
No, Jigri, they have gone
You come
to
to
the
my house, right? I say that yes, they came to my house, bought liquor, and they went to somebody else's house. That does not mean anything. On the way, it might have happened. They might have. I am saying on the basis of whatever you told me. They said that they would go to Mr. Jigri's house, but he was not there along with them, accompanying them to Jigri's house. That does not mean anything.
That part, there is no other independent witness.
FSL is your best part. Your two best arguments are this 8 years already in custody.
Yes.
No,
So
but
6 years, 6 years, 8 months.
6 years, 6 years. But he is life has been given. He's a lifer.
True. Liquor, there is a story of having liquor, but
Liquor is different. Liquor does not.
but the PM report as
That's
well as
irrelevant. Liquor is irrelevant. They purchased liquor. They might have had it.
there is no other independent evidence. Only the last seen together, that is not even conclusive chain.
Not very
Even
impressive.
date of occurrence is diverse. This is
Data-
the only thing.
PW 13 and PW 14, they might not have knowledge. They were not present anywhere. The brother-in-law and father-in-law. They gave their own version, but that does not demolish the principal case. The plinth of the case is that the person who gave the kukri, which was produced in evidence, that person said taken on 11, written on 12. Now, PW 2 says 12th,
Yes.
and court come to a finding it's 12. Last seen together on 12th. So 12th is not demolished by PW 13 and 14. 12th is not demolished by 13 or 14. And went to Jigre's house. He was told that they were going to Jigre's house. On the way, he might have done it. So this does not. Life sentence 302 is
Caesar
very
list
good.
was on 15.
Maybe. So what? What is the difficulty in
So
Caesar
not
list?
from me, from PW 11. It is not that leading. I'll pass you to the leading statement. Caesar has been made to that from me anything. I am harping upon that there is no cleansing or any best quality.
Did
of
you
evidence.
cross-examine PW 11?
Yes.
So let us see that.
I worked as labor. I keep cookery at home. Not a fact that on 11th of 10th of 2019, Baldev Lohar did not ask for cookery and he did not take it from me. Not a fact that after 3 days, Baldev Lohar
See, I
did not-
stated to the police that after the incident, Baldev took alcohol and moved around the whole village telling people that he had cut a human being with his cookie.
But alcohol was not found in the
Alcohol is illegal.
but the some
With
part
or
of
without
the,
alcohol, murder is the same.
true, but the some part of the evidence of the story
There was
has not,
sufficient evidence to connect them. There is no break in the chain of events.
there is in the cross-examination fourth line. It is
See,
fact
in the
that I did not
cross-examination,
see.
there is no insinuation that this person was involved in the crime. This PW11 himself. It was recovered from him.
No,
He
but-
said that taken by you, returned to him on
Yes,
12th.
but there
So
is
there is no, because he could not have any intention. There is no cross-examination on him, no suggestion put to him on his intention, his involvement in murder. Otherwise, it could be recovered from him.
fourth line, kindly see.
Yes.
Cross-examination. It is fact that I did not see Baldev Lohar
No,
committing
he,
any
not,
such
he
murder.
did not, he never says he saw.
Yes,
Taken from him, returned to him,
Yes.
recovered from him.
yes.
How did the police come to know about the murder weapon? From you?
No, from PW11 itself. I have no nexus.
They investigated, they found that it was
But
taken.
how can I
He was
mean,
last seen together, no.
last seen together has not been, there is a pitch that last seen together has
Last
been,
seen together, you
diluted.
went together from this PW11's house. You went out together from this PW11's house. You were last seen together. The weapon was produced. Everything goes against
but the
you.
last seen together, the theory of last seen together valid by PW11, by
PW10 itself.
PW10 itself. So kindly see.
PW10 is another person.
He is an independent witness.
No, he's not belying it. He rather says Baldev and Babula left his house together.
Then went to S.G. Gray's house.
He says they went to Zigre's house. He never accompanied them to Zigre's house.
No, on 12th of October
And they
2019, I
went to
was at
house of
home.
S. Zigre.
Dusra, Tika and guest, and he came to my house, Tika, Baldev and Babulal came to
No,
my house
Mr.
and
Shah,
they
no.
asked for liquor
No.
and they,
No.
and they, so and so. Thereafter, they left my house.
What is
And
the
they
stage
went
of
to
the
the
appeal?
house
The
of
appeal may be
SGB.
expedited? No way. What is the stage of the appeal? Paper books have been prepared.
No,
Directions have been given for preparation.
perhaps there was given. I don't know. I need to check the order sheet, whether there is a direction or not.
The call for the records is there. Huh?
Other witness are here.
Yes,
All other witnesses are hearsay. Total as many
we are
as
not
six,
looking
seven,
into the other witnesses at all.
seven witnesses are hearsay.
Maybe. No, sir.
So kindly, the substantial time he has suffered. 6 years.
The present appeal has been preferred
Appreciate one thing that
against,
there is no immediate scope for hearing of the appeal. Lordship.
against a conviction by life sentence on the inter alia under section 302 of the Indian Penal Code. So next para, learned counsel for the appellant, in support of the bail application, submits that there were 4 versions of the date of the alleged offence, whereas PW 14 stated such date to be October 10, 2019, PW 13 apostrophe version put the date at October 8, 2019, whereas PW 11 stated that a kukri, within bracket the murder weapon, bracket closed, was taken from him by the appellant and returned to him on October 12, 2019, and PW2 stated that the offence was committed on October 12, 2019. Next para thus, it is argued that the prosecution case was palpably demolished but not taken into consideration by the learned trial judge. The next para, secondly, learned counsel submits that from the evidence of PW10, one of the prosecution witnesses, it would be evident that the appellant and the victim came to his house on October 12, 2019, and thereafter they went to the house of one S. Zigre, Zigrey. Next para thus, the said evidence demolishes the case that the offence was committed by the appellant. Furthermore, next para, it is argued that no FSL report in respect of the weapon was ever produced in evidence. Next para, Learned AAG, appearing for the state, vehemently opposes the prayer for bail, comma, particularly in view of the gravity of the crime. Full stop. Next para. Upon going through the materials on record, comma, this court is of the opinion that since the appellant has suffered a conviction by one court and the nature of the offense is grave, comma, there is no scope of grant of bail. Full stop. Next para. Insofar as the arguments of the appellant are concerned, comma, the apparent discrepancy regarding the date of death, date of the offense is superficial. Full stop. Next para. Fact remains that PW 11, comma, from whom the murder weapon was taken by the appellant and returned on the date of the murder has corroborated such event. Full stop. Next para. PW 2 has also stated that on the date of the offense, that is October 12, 2019, comma, the offense was committed. Full stop. Next para. The statements of PW 13, comma, the father-in-law of the victim, and PW 14, the brother-in-law of the victim, are irrelevant in view of the clinching evidence given by PWs 2 and 11. Full stop. Next para. Secondly, comma, the mere statement of PW 10 that the appellant and the victim came to his house and thereafter left for the house of one S. Zigre cannot demolish the fact that the accused and the appellant were last seen in the house of the PW 10. Full stop. Insofar as they are going together to the house of one S. Zigre, comma, it is not the case of the PW 11, PW 10, that he accompanied the accused and the appellant and the victim to the house of S. Zigre. Full stop. Thus, comma, such destination, such purported destination of the appellant and the victim is the mere statement of PW 10 on the basis of the impression given to him by the appellant and stroke or the victim. Full stop. Next para. Moreover, comma, the non-production of the FSL report is not relevant, comma, since the weapon was recovered from the house of PW 11, comma, from whom the appellant took it and returned it. Full stop. Obviously, comma, at the time of recovery, comma, there would not be blood stains on the weapon. Full stop. Next para. In such view of the matter, comma, we do not find such a high case of discrepancy or perversity made out by the appellant so as to grant bail, comma, keeping in view the heinous nature of the offense and the gravity of the same. Full stop. Accordingly, CRA within bracket DB 12 of 2026 is dismissed. However, comma, we expect that the paper books are filed soon and the appeal be expedited.
At this stage,
এটা একটা কপি ফেরত দিন।
at this stage.
দুটো কপি ফেরত দিন, দুটো কপি ফেরত দিন। Yes. Next.
Actually, just two things. One is instead of age, it will be triple age. And plus, I think the CRAN would be dismissed, the CRA would be there.
Oh, sorry. The CRAN, this is CRAN 2.
CRAN two.
CRAN 2 of 2026 is dismissed. Sorry.
I'm okay.
Number 4.
Thank you.
Lordship, this.
That's
There's a delay.
the limitation act is there, 271 days.
271.
271 days.
What is the ground? This is legal aid?
No,
No.
Lordship.
What is the ground?
Ground is that this appellant is continuous judicial custody since 23/12/2021 and due to his financial conditions, he is not able to provide this and advocate, and that's why they deliver.
Mr. We are recording your opposition. We're recording-
Vehemently object, but
Vehement. What is the offense?
offense is
Clearly.
very serious. The
Yeah.
person, he was the railway guard on that railway, these persons, they are entered into it. The railway gate was down. They asked him to open the railway gate. He refused. He was murdered on the spot, brutally murdered. And these people, they have previous antecedents also of threatening railway officers.
Achha, we'll come to that immediately. First, let us allow this section.
That's the same.
Heard learned counsel for the parties, Fusup learned AAG appearing for the state, seriously opposes the prayer for condonation of delay. Fusup. Next para. However, comma, we find from the averments made in the application that the appellant was in incarceration during the relevant period and is of meager financial resources, comma, which prevented him from taking prompt steps for preparing the appeal. Full stop. Hence, comma, sufficient reasons for the sufficient explanation for the delay has been made out. Accordingly, CRAN 1 of 2026 is allowed, thereby condoning the delay in preferring CRA within bracket DB 25 of 2026. Yes, this is bail. Next.
No, that is also another applicant, the same case. This is also coordination of due.
Why two condonation applications for the same appeal?
Same appeal. Different persons, grounds is different.
The deal. Acha, very well. No, but single appeal,
Single appeal, 4 and 5.
why should you file two condonation applications? One appeal, two condon, it has to be condoned twice.
No,
No, no, this order itself can be passed in both CRA 1 and 2.
1 and 2.
Yes. In view of the order passed in CRAN 1.
I'm just sorting out. The second application is a bail application.
No, no, CRAN 2 is different prayer. What are you
It's a
saying?
bail application.
Bail application.
Bail.
Move the bail application.
1 is times.
We are ready.
On the prayer of the appellant, CRAN 2 of 2026 adjourned for the day. You take it so casually, a person is languishing behind the bars. He may languish after the bail being moved also, but he has a chance. So casually you are saying two condonation applications for the same appeal. Never heard of it.
Item number 5.
এটাতে দুটো অ্যাপিল ছিল
Same as in 4 minutes. Oh, the applicant is not here.
না এটা কত ডাকলে এটা ওনার আরেকটা
Yes. This was the second accused. Same order will be passed, but the appellant is not here.
same order exactly same order
None for the
delay in CRA DB 26 of 2026 হবে শুধু thank you same order adjourn tomorrow adjourn till tomorrow
Fine number.
Item number 6. Yeah, please, your lord.
Worship, this is a matter under 302
Yes.
once again, and appointed by legal aid committee.
Ah.
Lordship,
delay is there
Lordship,
delay
delay is there, Lordship.
What is the
CRAN
delay?
1,
what is the amount of delay
Lordship, it's 92 days at page 4. And paragraph number 345 is the explanation.
how do you opposition
Object
level?
of no
Yes, yes. Learned this CRAN 1 of 2026 is an application for condonation of delay in preferring the appeal. Push up. Learned Triple AG opposes the prayer for condonation. Push up next para. However, comma from the averments made in the application, we find that the appellant was in custody during the relevant period, and due to financial constraints was compelled to take the aid of Legal Services Authority Kuch Bihar. Push up as such, comma, keeping in view the aforesaid circumstances, we find sufficient explanation for the delay having been given. Accordingly, CRAN 1 of 2026 is allowed, thereby condoning the delay in preferring CRA DB 28 of 2026.
Lordship, fine amount may be stayed. Fine of rupees 10,000.
Have you preferred any application for
Lordship, it's
stay?
a general process. At the time of condoning the delay, it's
In view of the, we're doing that. In view of the financial constraints of the appellant as indicated above, comma, the component of fine of rupees 10,000, 10,000 as incorporated in the impugned judgment shall remain stayed till disposal of the appeal.
Lordship, one indulgence, the paper book order.
Oh, acha. The appeal is admitted and shall be heard on the grounds taken in the memorandum. Issue usual notices.
Trial court record.
Trial court records be called for. The paper books shall be prepared. What is the usual time given?
Fortnight.
Paper books shall be prepared within 4 weeks. You are given because there is another. Within 4 weeks from date, puts up liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
Lordship, one indulgence furthermore.
Yes,
I'm giving trouble.
No.
Lordship knows that this appeal has been given by the legal aid authority, and Lordship also knows that I appear on pro bono on all the cases. And Lordship previously Lordship has passed a similar order that if my junior is also appointed, so that the expenditure can be made by. If I get a junior from the legal aid authority, like.
What is your full name?
Abhishek Sarkar.
Sarkar. Mr. Abhishek Sarkar, who is assisting Mr. Ganguly, learned counsel appearing for the appellant, is directed to be appointed to assist Mr. Ganguly in prosecuting the present appeal by the Calcutta High Court Legal Services Committee.
Deeply obliged.
His appointment shall be regularized.
The appointment shall be regularized.
His appointment for today's appearance shall also be regularized.
Great.
His appearance for today's matter. His appearance for today be also regularized. Yes.
Number 7.
7.
May I please, your lordship, similar order, 302, 10,000.
Deal of 176 days.
So exactly same order. Lord CRA DB 29 of 2026. আগেরটা যা হলো তাই order.
Lordship, except the last paragraph.
Last part. My part is I'm not here. He is.
আচ্ছা লাস্ট পার্ট যেটা বলেছি ওই সৌরভ গাঙ্গুলি অভিষেক সরকারকে রেগুলেশন ওই পার্টটা হচ্ছে।
I'm great.
Thank you, Mr. Mishra, for cooperating in these matters because we know the trouble you people are going through.
For all the matters for the brief is there, we are ready.
No, we understand.
Number 8.
Yes, habeas.
For the
Yes.
petitioner hearing. This is a habeas corpus petition, my lord. My lord, there is a communal issue revolves this petition, my lord. The
What issue?
petitioner- Communal issue.
Communal issue.
The petitioner is a Muslim
Yes.
and his wife is Hindu. So the after marriage, my lord, the in-laws, petitioner's in-laws came to their house and took the wife on the pretext that let her go with us for 2 days. We'll send her back.
She's a major otherwise.
Yes, my lord. Major. So from then, my lord, since then, my lord, she has not been traced out.
Who should we direct which police station?
First of all, my lord, we tried to lodge
You
FIR,
are
my
appealing
lord.
the matter, Mr. Mishra. You have been.
We are ready with this.
Let us hear him, then we'll come to it.
First of all, my lord, we tried to lodge the FIR. The police denied.
What
Yeah.
is the police station?
My lord, Khoribari police station, my lord.
Khoribari police station is your in-laws house.
No, my lord, the jurisdiction. Yes, my lord.
She has been kept in. All both of you reside.
Yes, my lord.
So let us hear the explanation from the state.
My lord,
Yes.
because a threat has been come to me to relieve from this case. So that's why I want to.
To
say-
you.
Yes, my lord. The officer, the duty officer first denied to take the complaint. When I intervened, he threatened me that this is a communal issue. Being a Hindu, you should not take up this matter. And secondly, my lord, what he has done, kindly come to page.
Are these averred in the petition?
No, my lord, because it was
So
my
you will record
personal
your
view.
submission.
That's why.
You can record your submission. No, you
My
are a member of the bar. No,
No, my lord, kindly see the FIR at page 29. The written complaint, my lord. Sorry, written complaint, my lord. Page 29. They have written, kindly see on the,
whose complaint is this? They.
no, my lord, this is the complaint lodged by the
You.
petitioner, my lord. Petitioner, my lord. What they have written, the officer, kindly see, my lord, on the left side, written, RITEN, written, Advocate Kumar Santanu. And he wrote my number there,
Page 29.
29, man. RITEN, written, Advocate
the-
Kumar
the-
Santanu, mobile
That's
number.
his linguistic problem. So that does not vitiate the FIR.
No, my lord,
If you
but
go by that, many judgments will be vitiated. our
this
judgment.
was done intensely. He took my number, he took my name and
as
wrote
if,
this.
as if you are.
Yes, my lord.
It's written in block letters that. No, not even block letter.
But the,
Achha. So, but a different story was made out here.
my lord, the story was
is
same,
right.
my lord.
Story is right.
Story is right, my lord.
So how does it matter?
I have already enclosed the marriage certificate, my lord.
No, written by Advocate Kumar Shantanu. How does it make a difference?
No, my lord. I am telling that after
Because
receiving
the
the
typo is there, it should be WRI instead of.
No, no, that is.
that is there, my lord. But he threatened me, and when he saw that I did not bend down, he did this thing.
So this is not very incriminating against you.
No, my lord.
So
That
you
is
have
not
written
incriminating.
it. He has written that you have written it.
But the fact is that, my lord,
He has
both
written
the,
that you have written it.
my lord, he tried to prove that I have written this. Now, my lord, the fact is that both the petitioner and his wife both are major, my lord. There is a marriage certificate under Special Marriage Act, my lord. Even the marriage officer was
She is
hacked.
now, according to you, with her
Major.
parents. Let us hear, Mr. Mishra. Yes, Mr. Mishra.
But first off, I really apologize if at all something like that has happened. That shouldn't.
Then obviously.
Because Milords,
What is your version? The state?
my version, Milords, the way we have received it is,
Yes.
the husband and this girl, she got married with this person, writ petitioner hearing. Yes, there are certain communal tension that is happening there, but the girl out of her free will, she residing with the family of, with her own family. And Milords, if the direction be so, I will ask the IO to bring the girl here. That obviously.
Not
the
in
purpose-
open court, will
the
hear
purpose
her
has
in a
to be-
chamber
the purpose
and
has
both
to
of
be-
you may be present there.
That would be there.
My lord, I have
a
enclosed
different
the.
point.
No, IO will, why should the IO bring her? I mean,
There is no IO, no case as such has been
exactly,
registered.
yes.
The officer will, officer will. do
Officer
the
will accompany her.
he will accompany her. I will ask a lady officer to be there. That
Yes,
also
yes,
shouldn't be an
yes,
issue.
yes.
The
my
issue
lord-
herein is,
No,
My
let
lord,
us let him
meanwhile-
complete.
Ma-
Let him complete. Yes.
Apology.
the issue herein is whether a habeas corpus petition like this is maintainable before the honorable court or not.
Why do you say no?
Yes, not. These are all matrimonial disputes at the end of it.
We don't know yet.
From the marriage certificate, all I could gather is that the lady, she is a major. Obviously, because she has married also.
How do we know before, unless she comes before us, that
That
she
is
has gone off her own
That is-
volition?
I will, my lords may kindly keep it on Monday. But my submission still would be, my lords, this is a misuse of a habeas corpus
No,
petition.
no, I'll record. We'll record that. We'll record everything.
My lords,
And
let
yes,
it
you
be
read
on
the
Monday,
My lord,
and then we
I
will
have
see.
enclosed 2 pen drives, my lord, as annexers. They are
Also,
in the
without any
envelope.
IT certificate, what pen
No,
drive
no,
is there?
that can be verified. That can be verified.
Pendrive show what?
My lord.
What do they contain?
The content is that, my lord, there is a recording of the girl stating everything, that she has been forced by her family
Recording
to
by
depart.
over mobile phone.
Yes, my lord, the selfie. Well, she is.
Send
And second, my lord, is the family members and the some more 100 people who came and vandalized and threatened them, the petitioner. Everything is there, my lord.
Monday. What time would suit you, Mr.
First item in the morning, my lords, habeas corpus has to be given prior.
No, no. She will meet her in the chamber.
Then whatever, my lords.
So they no. Why wait for Monday?
My contention is habeas corpus petition are festinum remedium. It cannot be issued in matrimonial disputes like this.
Yes, sir.
Learned counsel for the petitioner submits that the what is the name of your wife?
My lord, her name is Kiran Kumari Swarnakar.
Swarna Kant.
Swarnakar.
K.A.R..
Learned counsel for the petitioner submits that the petitioner's wife, Srimati
Kiran
Kumari
Swarnakar
Swarnakar.
was forcibly taken from him by her in-laws. For sub next para, it is submitted that the backdrop of the case is communal in nature. Full stop. The petitioner, comma, it is submitted, comma, is a Muslim by faith, whereas his wife is a Hindu. Full stop. Due to such reason, comma, the marriage between the parties were not accepted well by the in-laws of the petitioner, and they tried to incite communal tension, comma, leading to the unlawful detention of the petitioner's wife by the said in-laws with the active cooperation of the police. For sub next para, in support of the last above named contention, comma, learned counsel submits that counsel personally, comma, when he met the officer in charge of the concerned police station, comma, was threatened, full stop, by placing reliance on the handwritten inscription on the written complaint, comma, it is submitted that in that the officer in charge himself took the phone number of learned counsel and put it underneath his name, which was also written by the officer in charge himself on the complaint. Full stop, next para, learned counsel submits that that pen drives have been filed along with the writ petition, which contain recordings, video recordings,
Yes, ma'am.
video recordings indicating that the wife of the petitioner has been forcibly detained, and the entire background of the case will also be evident from the said video recording. So next para, learned triple AG appearing for the state vehemently opposes the prayer and submits that the contents of the pen drives cannot be looked into since in the absence of compliance of the necessary formalities under the Bharatiya Sakshya Adhiniyam within bracket BSA, bracket close, full stop. Next para, secondly, comma, learned triple AG contents that a habeas corpus is not maintainable to canvass matrimonial disputes, full stop. Next,
Festinum remedium, the appropriate remedy is 97 CRPC.
the appropriate remedy would be section 97 of the
CRPC is BNSS.
no,
Oh,
now
the section would change. I'm so
of the
sorry.
appropriate section of the BNSS. Full stop, next para, be that as it may, comma, unless the
And the allegation of threat loss needs to be verified.
next para, learned counsel and learned triple AG also controverts the contention allegations made otherwise by the petitioner. Full stop, next para, be that as it may, comma, unless the wife of the petitioner is produced before us, comma, it would not be clear to the court as to the circumstances leading to her parting with the petitioner. Full stop, accordingly, the whom shall we direct, Mr.
Yes, the-
Mishra?
The officer in charge of the Khadiwadi police station needs to be directed.
The officer in charge of the Khadiwadi police station,
Respondent number 4.
that 4 or 5?
4.
4.
5 is private respondent.
Acha. Being sorry. Yes. Being respondent number 4 is directed to ensure that Kiran Kumari Swarnakar, comma, the wife of the petitioner, is personally produced in chambers before us on June 15, 2026 at 1:30 p.m. 1:30 p.m. Full stop, learned counsel for the parties would be entitled to be present at the time of such
That might not be required.
permitted.
Let her interact with my.
Very well, very well. I said the second
Our presence
particular.
might not-
Great, thank you.
My lords.
Well, thank you. The matter be listed next on June 16, 2026 at the top for further orders.
Deeply observed.
Thank you. 16 June at the top for further orders. আর ফাইলটা সোমবার যেন আমাদের কাছে থাকে।
My lord, subject to correction, my lord, in that the statement where it is written that I physically went, no, my lord, it was over phone, my lord. There is একটা লাইন আছে না?
কোথাও যদি বলে থাকে যেখানে কাউন্সিল ওয়াজ থ্রেটেন বলেছি ওভার দ্য ফোন করে দিই ফোনটা
ওটা over the
ফিজিক্যালি বলে থাকে সেটা
Deeply observed.
থ্যাংক ইউ
Item number 9.
Like I am on behalf of the applicant.
यस
इसका एक रिटर्न आर्गुमेंट बनाया था वो कहाँ है?
Sarkar, you had submitted that the appeal may be heard at along with the yes. Only if it is short, the points are short. If it's very extensive, then other matters will suffer. Should it?
This person is in custody for the last 5
No,
years.
that we appreciate fully. Or should it take up the call up to at least the order for 2 and the civil applications first, then take up this?
As your lordship pleases, my lord, I have.
Mr. We are just passing over 10 also similar. 10, Mr. Mishra. 10 you are appearing. 10 you will do the matter.
Yes, I will do the matter.
So 9 and 10 both you are there. So we are just passing it over. We'll call up to 21. Order for 2 and applications. Probably nobody will be here. If somebody is there, we'll just share it. We'll take 5 minutes in each. Pass over. 9 and 10 pass over করে বাকিগুলো ডাকো 11 থেকে ডাকো 9 and 10 তার এই 21 এর পর ডাকলো।
Item number 11. 11, my lords. I'm for the
Yes.
appellant, my lords. I was informed just yesterday by the client, my lords, that the appellant number 2 has passed away. My lord.
Learned counsel for the appellant submits that the appellant number 2 has passed away in the meantime and seeks leave to take appropriate steps for substitution. Push up such leave is granted. Push up. Let the matter go out of the list with liberty to the appellants to mention for inclusion in the list as and when such substitution application is filed.
Grateful, my lords.
Whenever it is filed, mention it, will include
Grateful, my lords.
appearances. Next.
Item number 12.
দাও আছে।
Lordship, item number 12, I'm praying for time, Lordship.
Why?
Lordship, in this matter, Mr. Shankarnath Mukherjee is supposed to appear, Lordship. That's-
No, you do the matter. We cannot
Lordship, as
indefinitely
per the
adjourn.
direction,
On the last occasion, he did not appear also.
Lordship, as per the direction, my instruction of my client, I am submitting, Lordship.
Learned counsel for the appellant seeks an
17th,
adjournment. Push up as a last chance to the appellant to argue the matter.
17th,
The same is adjourned till June 17,
Lordship.
2026.
Grateful, Lordship.
আচ্ছা এটাতে দাও এটাতে আরেকটা কারেকশন হবে প্যারাগ্রাফ দিয়ে in the order dated June 8 2026 comma the date was transcribed erroneously as 06.08.2026 full stop let the said date be read as 08.06.2026 অঙ্ক শুভ্রকে একটু সাবধান থাকতে বলো মানে অনেকগুলো ম্যাটার এটা করে বসে আছে আমি তো ডেট দেখি না
Item number 13.
It's 13 and 14, I'm being led by Mr. Vikramaditya Ghosh.
Yes, sir.
Mr. Vikramaditya Ghosh, my lords.
Where is
Praying for
14?
a Day's accommodation, as to, my lords, properly prepared, my lords, so as to.
13 and 14
Yes,
14 is
any day
separate.
next week, my lords.
14 is separate.
14 is a different matter, 13 and 14, my lords, we are appearing,
no Mr. Vikram Ghosh is common
my lords.
13 14 দুটোই on the both 13 and 14 দুটোতে একই অর্ডার রেকর্ড on the prayer of the appellant the matter is adjourned for the day
I'm grateful.
Because that matter which was not discussed twice. You would remember Mr. Dash was here.
this is a restoration application
Yes, sir. The application was restored by your lordship, subject to the fact that they would move it this week itself. This was that.
not today only that is this week 14 13 14 both not today only so tomorrow please remind us if they ask for time
Yes.
yes
I'm grateful,
thank you but you come prepared if Mr. Ghosh is not there you have to start the matter at least
my lords.
what is the matter about
It's, item.
yes you know very well
Item number 15.
Yes.
15, my lord, I'm appearing for the appellate. My lord, the plaintiffs are. My lord, the plaintiffs are the appellants, my lord, in a suit for declaration of title and.
take the microphone a bit
My lord,
closer.
the plaintiffs are the appellants, my lord, in a suit for declaration of title and permanent injunction. My lord, the background of the case is that.
both courts you lost in both courts
No, my lord, decreed in part, then the state was affirmed by the learned appellate court.
Tell.
My lord, the.
What portion was decreed? What part was decreed?
The right title and interest with regards to plaintiff number 2 was decreed.
Huh.
The right title and interest with regards to plaintiff number 1 was dismissed.
So this appeal is by the plaintiff number 1.
No, my lord,
Both have no difficulty. Both have preferred.
both are preferred.
No difficulty. Yes. You filed together, so you
Yes.
can prefer. Yes.
Now, my lord, the factual background of the case is that, my lord, both the plaintiffs have brought the suit properties from the defendant itself. Now, thereafter, my lord, defendant started disturbing the possession of the plaintiffs. Plaintiffs preferred the suit. Now, in the suit, my lord, my deed of sale was produced before the learned court. my title as well as my deed of sale was admitted by the defendant. Now, there was a discrepancy between the.
Admitted by the defendant.
Yes. Now, there was a discrepancy between the.
One second, the defendant sold it to you.
Yes.
Discrepancies?
The discrepancy is that, my lord, the boundary and the sketch map, according to the trial court, according to the learned courts, that they are not matching with each other. Now, my lord, that is a seller proposition of law. If there is at all any discrepancy between the boundary and the sketch map, the boundary will prevail. I'm not ignoring that. Both the courts have passed and decreed that the deed itself is ambiguous, as well as declaring that the plaintiff has no title in the suit property.
In the deed itself, there is an indication of the property being sold.
Yes.
No, why only for there were two, you purchased by two title deeds?
Yes. Plaintiff number 2 has a separate deed, plaintiff number 1 has a separate
So
deed.
plaintiff number 2, his deed was fine. The sketch map tallied with the
Yes,
one.
yes, yes.
It was regarding you. Let us see the finding of the
Yes,
appellate court or whichever court, because it's an affirmance judgment. So you can
Yes, my
press
lord,
either of the courts.
My lord, without troubling to your lordship.
The relevant portion regarding
Yes, my
this.
lord, only the relevant portion.
Can we see the deed first?
Yes, my lord.
Show us the deed first.
My lord, that will be
Your deed, obviously.
my lord,
Page 17.
the application number 2, my lord.
Yes, page 7.
No, my lord, that is not my deed. My lord, my deed starts at, my lord,
page 30.
page 30.
30, right.
My lord, without troubling to your lordship, my lord kindly comes to page number 33, rather
Yes.
32, which is the scheduled property.
Yes, yes.
My lord, in the scheduled property, my lord kindly turns over, page
Yes.
33.
Chohoddi.
Before Chohoddi, my lord.
Yes, yes.
In the middle, Jodi pe LR, my lord, the fourth line from the top.
Jodi pe LR.
Jodi pe LR 6243 number খতিয়ানে LR 2249 number দাগে এত একর জমি. That is the suit property. My lord, there is a boundary given. Now, my lord, kindly turns to 35 now. That is the, my lord, sketch map. Now, the trial court holds that after 2249 there is a gap. Prior to, my lord, on the eastern portion, before Alipurduar Road, my lord, there is a gap. According to the trial court and the defendant, as has been stated in the written statement, that there is a plot number 2248. Now, my lord, no document has been shown with regards to the title of 2248, as the defendant claimed that it is his title.
This
his
appeal will be heard on the following substantial question of. You are appellant number 2.
Both.
Sorry, the plaintiff number 1 is appellant number 1 here.
Just a minute. Yes, my lord.
The second appeal, this second appeal will be heard on the following substantial question of law, whether both the courts below substantially erred in law in relying on the sketch map annexed to the purchase deed of appellant number 1 in coming to the conclusion that the same did not tally with the boundary given in the body of the deed, comma, thereby coming to the conclusion that the description of the property in the deed was ambiguous, comma, by overlooking the settled proposition of law that in the event of any conflict between a sketch map annexed to a deed and the contents of the deed itself, comma, the latter will prevail. Any interlocutory application?
My lord, yes, can 2.
Section 5 was there, that was allowed.
That has been allowed, my lord. I have served as well.
Can 2
only
is for
one-
stay, what?
My lord, stay
No
of the
question
order.
of, no scope of stay.
Yes.
Stay would defeat the rights of appellant number 2.
Yes.
So what have you prayed here? Stay.
Yes, my lord, I have not been drafted, but
No, we understand, but we'll dispose of. We'll not done stay, but you pass the usual directions for service of goods.
if my lord kindly takes up page number 14 of the application,
Yes.
lord, it has been drafted in the form of a civil revision. But
Civil
regardless,
revision.
Yes, my lord. If the prayer, if my lord kindly goes through, generally in a civil revision in the High Court, we draft in this manner the prayer portion.
No degree.
My lord, only one thing, my lord.
Yes.
My lord kindly adds up another point of law, that is when the title of the plaintiff has been admitted, can the court.
Very well. Yes, you're right. Substantial questions of life. Forgot that. Substantial questions of law bole 2 ta kore dao. Whether, comma, in view of the categorical admission of the defendant stroke respondent as to the title of both the appellants, comma, both the courts below committed a perversity in disbelieving the title of the appellant number 1. Can 2 of 2025 is an application for stay of the impugn judgment and degree, full stop. However, comma, grant of stay would not inure to the benefit of the appellants, semicolon, rather, comma, the interests of appellant number 2, comma, in whose favor both the courts have granted a decree will be defeated. Full stop. As such, comma, we are not inclined to grant any stay. Full stop. Accordingly, can 2 of 2025 is disposed of by directing the appellants to put in the postal costs and requisites for service of notice of the appeal on the respondent within a fortnight from date.
My lord, make it 3 weeks, my lord.
Within 3 weeks from date, push up. The trial court record shall be brought by special messenger at the cost of the appellants, also to be deposited within 3 weeks. So next para, the appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants.
My lord,
Liberty to mention the appeal for inclusion in the list before the appropriate learned single judge having determination as and when the appeal is ready for hearing. Yes.
only one humble. My lord, my
No
lord,
rest to cost করে দিন।
my lord, my lord, kindly direct the defendant, rather the respondent, to not disturb my peaceful position, my lord.
You have to file a proper injunction application. for it. File an injunction application before the learned single judge will get. We need not advise you, but show the current cause of action to be current then.
I know, my lord, I just took my chance.
Yes.
But 16.
16 কি? আবার লিস্ট না দিন। এই ছোট লিস্টের প্রবলেম। 16 কি দেখি? না দেখি কোনো অর্ডার আছে আগে? ফার্স্ট টাইম আসছে? None appears for the appellant at the time of call, full stop. Let the matter stand adjourned for the day. কলকাতা থেকে করছে। একদিন টাইম দেবো অল্প দিন আছে কেন ভাবছি যদি ছেলে বলে বেশি নিয়ে যাচ্ছে লাস্ট চান্স আগে কোন অর্ডার আছে ইউ আর অ্যাপিয়ারিং
My lord, I am for the
respond yes
My lord,
very silent yes what is the matter
my lord, there is a delay in filing the present application, my lord. My lord, this is an
application is-
appeal against appellate order, my lord.
Appellate. The appeal is this is appearing for the first time restoration application
Restoration application has already been allowed, my lord.
allowed
My lord,
you
subsequently
have
there
not
is,
filed a section 5
yes, my lord, section 5 is yet to be filed, my lord.
then
And my lord,
Learned-
stay application is also.
learned counsel for the appellant seeks submits fairly that the appeal is time barred and seeks liberty to file a condonation application as well as a stay application. Full stop. Accordingly, let the matter go out of the list.
My lord, kindly fix it on Monday, my lord. In the meantime, I will file the section.
By Monday, you can do it.
Yes, my lord, by Monday.
Very well. Accordingly, let the matter stand adjourned till June 15, 2026. Full stop. Liberty is given to the appellants to mention the applications as and when so filed. You file it, try to file it today itself then. Do you have access to your client?
No, my lord, it will require, my lord, to one
And
or two
how
days,
can
my
we
lord.
list তাহলে ওটা returnable date 16 করে দাও 16 you file it tomorrow
Yes, my lord.
mention the number on Monday we'll keep the
My lord.
applications
My lord.
এমনিতেও যদি অ্যাপ্লিকেশন আসে কোনো পেন্ডিং ম্যাটার যেটা রিটার্নেবল ম্যাটার আছে তার সঙ্গে দিয়ে দিও কিন্তু দিয়ে দাও
Great.
থ্যাংক
18 lordship.
yes what is your
My lord.
yes Mr. Mukherjee
My lord, this is the
Yes,
matter.
yes.
On the last occasion, I drew lordship's kind attention to order dated 8th April 2026. When my restoration application was allowed. And
yes
Restoration allowed, but I'm sorry.
you happy
One humble prayer, my lord.
no what was Mr. Mukherjee you complete first
Yes,
what was that
This is my appeal. If this appeal arises out of the order
no
from the
order dated 8th of April what was there what was recorded
order dated 8th of April, lordship kindly sees the can 2. This is an application for restoration. The reason for default in appearance stated in the application is
Oh,
found
oh.
to be sufficient for allowing the restoration. Then
Yes.
the lordships
Right,
directed
right.
that the affidavit be exchanged for can 1. Now
but
can
the
1
affidavit
is
the
already
registration
disposed of.
can
Yes.
one can one had already been disposed of
Yes.
Can 1 already
Previously.
disposed of by lordships
Disposed of.
in the sitting in the principal bench.
Principal.
Acha, so now what is to be taken up? The appeal is otherwise ready, or can 3 is to be
No.
taken up?
Can now the can 3 was never disposed of. Can 3, my humble submission is to be construed to have been disposed of in view of can 2.
Can 3 was what? Can 3 was the delay
Was condonation.
condonation in the restoration.
Yes,
Yes.
I have
You're considering
understood.
it to be yes.
Yes.
With my strong
Yes.
objections.
Learned counsel for the appellant,
Number-
appellant submits that video order dated April 8, 2026, comma, can 2 of 2026, comma, an application for restoration of the appeal was allowed. For sub next para, can 3 of 2026, comma, however, comma, which is an application for condonation of delay in filing the restoration application, was not formally disposed of. For sub learned counsel submits that in view of the restoration application itself being allowed, comma, it ought to be deemed that the delay in preferring the same was also condoned. Full stop. Next para. Learned counsel appearing for the state vehemently opposes such, appearing for the respondent vehemently opposes such prayer. Full stop. However, comma, from the tenor of the order dated April 8, 2026, passed by a coordinate bench, comma, it is evident that since the restoration application itself, comma, in connection with which the condonation application bearing can 3 of 2026 was filed, comma, was itself allowed on the finding that sufficient cause for default in appearance was shown, comma, it is to be deemed that can 3 of 2026 was also allowed. Full stop. Accordingly, can 3 of 2026 is disposed of as infructuous in view
I
of
am
the
so obliged by that.
delay in preferring the restoration application having already been condoned. Full stop. Next para. No other application is there.
No.
No other
So
application
we'll
is there.
pass usual for preparation of
orders,
paper and record.
Yes, yes.
Kindly
Very.
allows
In view of the
the trial court
in
records
view
to
of
be
the
brought in
appearance-
and paper.
In view of the appearance of the respondent through counsel, service of notice of the appeal on the respondent is dispensed with. The appeal be treated to be ready as regards service. The appellant shall, the trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a fortnight from date. The appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing.
Grateful.
I am obliged, my lord.
Thank you. You have any matter post lunch session also?
No.
My lord, I have to accept the applicant, my lord.
Yes.
Mr. Ghanashyam will appear virtually, my lord.
Mr.
Ghanashyam, my lord, he is there.
Yes, Mr. Ghanashyam Pandey.
Your Lordships, we had preferred an appeal, but due to
No, this is a restoration application or what?
Yes.
restoration.
Restoration application has been, restoration application, oh, none appeared. What is the
None.
reason for the absence?
Your Lordship, the advocate was not well, and as such, the junior could not be present. And
Very well. Since the date on which the appeal was dismissed for default, none had appeared for either of the parties, comma, we apply the principle of Order 9, Rule 4, read with Section 107 of the Code of Civil Procedure and take up the restoration application ex parte. So next para, from the averments in the application, it is seen that the learned advocate conducting the case for the appellant was personally indisposed on the date when the same was called on, and as such could not appear, comma, leading to the appeal being dismissed for default. Full stop. We find sufficient explanation for the delay, for the absence of the appellant accordingly, and accordingly allow can 1 of 2026, comma, thereby recalling the order dated April 21, 2026 and restoring SMAT 1 of 2026 to its original file and number. No address to cost. Let the appeal be listed on June 15, 2026 for admission, for hearing under Order 41 Rule 11 of the Code of Civil Procedure.
oblige, Your Lordship.
Monday come back, Order 41 hearing. Yes.
Oblige.
Why SMAT? This is against what? Order 21 Rule 197 to 101. Why SMAT? Hey, that doubt. SMAT can. What have you challenged?
Your Lordships, I have challenged the order that was passed by the in the Miss Appeal 5 of 2025, passed by the
Must have been Order 21 Rule 97 to 101. You are a third. Yes, yes. That is the only scope of filing a second miscellaneous appeal in our court. Come prepared on the next day, Mr. Pandey. Or you, whoever is free.
Number 20.
None appears to move the matter. Let the same stand adjourned for the day.
Item number 21.
Well, it's item number 21. I'm for the appellant. Well, I'm led by senior advocate Mr. HON'BLE. He's in court number 6 on his legs. Well, spring for a short pass over.
Lordship, prior to that, Mr. Nabankur Par is representing the OP number 1. Since he's not well, due to his health ailment, he could not appear before this court today. He's praying for the matter be fixed on Tuesday, Lordship. Tuesday or Monday, any day. Any day. Any day.
Which date?
Well, it's kindly Tuesday, my lords.
Tomorrow, half an hour, back pain. Back pain.
You are for which respondent? One.
Respondent number 1.
On the prayer of respondent number 1, let the matter stand adjourned till June 16, 2026. Tuesday.
Grateful.
Monday, there are already many matters.
Grateful,
Yes,
my lords.
yeah.
Grateful.
21 হয়ে গেল, এবার আবার। No, we take up the Passover matters. Mr. Thor.
22, my lord.
Passover matter item number 9.
Yes.
Oh.
You start the matter, Mr. Mishra will come.
3. This is a murder case where life imprisonment has been given, my lord. The FIR is in page number 2, my lord. The translated copy, my lord. My lord, landed Triple AG instructed me to fix the matter in second half, my lord, or my lord, second half or tomorrow.
Second half, we take up single. We
Tomorrow,
sit
because his matter has been fixed in court number 5. Tomorrow he has taken Passover. After that, my lord.
But we indicated clearly that which court it has been taken up.
My lord, Honorable Justice Shampa Dattopal.
That will not take much time. That is bail must be or anticipated bail something.
My lord.
Let him come back.
My lord.
You are passing it over, Mr. Shampa. 10 also similar prayer will be making. We laughed seeing his expression. No, where will be a passing over if all of you are present, then whenever Mr. Mishra comes, if either of you are present, then we'll take up that one.
Yes, ma'am.
Just please indicate to him that whenever he comes, we are waiting for him basically.
My lord.
So we are taking up matters in the meantime.
My lord, he also, my lord,
He was ready in the matter. Yes, we know that.
12:30, Vibhash Patna and Honorable Justice has also fixed another.
Let him do everything before he come back at 12:10.
Great.
After that, no time. Yes. Call.
Item number 22.
Yes.
As I appear for the appellants, this is a modification application preferred by the department. Mr. Ratan Banik is appearing online. He is for the department.
You are for the.
I am for the appellant. The case was disposed of in.
So it's their application for.
Yes, their application.
Modification. Is it can it be heard by the regular bench?
Yes. Since this order was passed by the then Chief Justice, T.S. He is not.
Acha.
My lord.
Second judge is not available.
My lord, kindly.
That is not required, my lords. In the circuit bench, my lords.
Yes, Mr. Bonik. Photograph has frozen probably. Yes, connectivity issues. Mr. Bonik. Let us see the order in the meantime. Can 3 the application?
Yes, Can 3 is their application.
Yes.
My lord, they have filed the affidavit in opposition.
After going through this, I will make my submission. 1 day accommodation is required, my lord.
Long back we filed.
When did you file opposition?
On the last hearing, it was filed in the court and it was served also, my lords.
Yes, yes.
That was in
It
the,
was filed long
Yes.
back, Mr. Bonik. Why couldn't you go through it?
My lord, as last chance, tomorrow I will make my submission after appearance
Very-
physically.
very well.
Mr.
One day
On the prayer of learned counsel for the appellant, the matter is adjourned for the day.
I'm grateful.
Opposition record nahi? Opposition was filed in court. You are sure?
Yes, it was filed in-
Let us check up
Yes,
before
yes.
you leave.
I have also received the opposition.
On the last occasion, it was filed on court.
তলায় আছে তো এগুলো না আলাদা করে রাখবে এরকম করে তো বার করে করতে পারো না they did not file any reply.
No, they did not.
No, no, we
Opposition টা
will
আলাদা
not find any reply, my lord.
Well, sir, come back tomorrow.
Great.
Tomorrow. And
তুই পরে আলাদা করে দে
next matter, my lord,
let it be just called on. Yes, next matter. Yes,
yes, my lord, next
Mr.
matter.
Bonik has
is
something to
also- My lord, next matter.
you had some
kindly
celebration
also
last
fix
night
it
or
tomorrow.
you are not ready in any matter, Mr. Bonik. You had some celebration last night.
No, no, practically, I was not in a position due to some family urgent
Acha,
issues, my lord.
Acha, very well. You need not say.
Tomorrow I will
So-
make.
Mr. Ghosh, any difficulty tomorrow? Very well. On the prayer of the, you are for the respondent here.
Customs, yes.
Customs.
Yes, customs
Yeah.
department.
On the prayer of the respondent, the matter is adjourned for the day.
Grateful, my lord.
You are really, what are you doing here in the front row?
He was informing that Mr. Bonik's younger son passed from IIT.
Oh,
So yes.
where is our treat and the rest of the bar has a,
Yes, my
because a
lord.
treat.
Just yesterday, I came back from Rajasthan.
Obviously, the great
That's
news.
right.
My lord, may I be
24,
permitted to appear virtually for the respondent?
Yes, absolutely, Mr. Singh.
State is the answering respondent.
You are for the private respondent.
My
Mr.
lord,
Singh?
this was
Oh.
my writ petition, my lord. My
No,
lord,
no,
we
understood,
have-
but state has
My
to be
lord.
there. You're
My
there.
lord, what, my,
No,
my lord,
actually,
there is a
allotment
difficulty.
is yet to, it has not been allocated.
Use the microphone. You're,
It has not been allocated yet, your lordship. Kindly fix this matter next week so we
but
can.
we are growing tired of this excuse of the state. I mean, it
My
has
lord,
to be allocated
may I
by someone.
indicate
It's
one thing,
appearing
my
in the list.
Lordship, the difficulty is what is the procedure right now is being followed in the civil panel is that if a matter is appearing in the list, subsequently from the Department of ELA, they are searching from the brief. If it has there in their compilation, they are allotting it. If it is not there, then again informing the previous councils who are appearing. In some matters, there is only one brief, your lordship.
If you want Ms. Acharya, but it's a very thick document, you should take it from your department. When should
May
you
I
keep
make a
it?
submission?
Next week.
Yes, Mr. Singhal, you were saying something. Sorry.
My lord, actually, my lord, if my lord goes through previous order, my lord, the appellant has filed an application seeking leave to appeal, my lord.
No, the state is seeking some time. So what can be done?
My lord,
They are
they
required
are
to be heard.
directed, the appellants are directed to file a reply to our opposition that we have filed to their leave application, my lord. Till date, they have not filed their opposition to the leave
So
application.
may not be required, it can be taken up, my lord. Tuesday, my lord,
Reply to, don't, need not file. Very well.
Tuesday, my lord.
Very well. An adjournment is sought on behalf of the state. Full stop. Learned counsel for the appellant submits that the appellant need not file any reply to the opposition filed to the leave application by the writ petitioner stroke private respondent. So accordingly, on the prayer of the state, let the matter stand adjourned till June 16, 2026, when it will next be listed under the same heading. Please come back on June 16.
Deeply obliged, my lord.
Thank you.
Grateful, your lordship. Deeply obliged, your lordship.
But
My
Ms.
lord,
Acharya,
next matter
please
is
ensure
same,
that
my
you
lord.
get the brief in the
The 24, 25, my lord.
24, 25, same order. Same order.
Item number 26.
ডিস্ট্রিবিউশনে যদি না থাকে কি বলবো বলুন তো? ওই নিন ডিসকাশনে নিন
Item number 26, I'm praying for short.
রিফিউজড মুভ ইট রেজিস্ট্রেশন অ্যাপ্লিকেশন নো টাইম
But I don't have brief also. Lordship,
ইউ আর দ্য জুনিয়র অফিসার অর্জুন চৌধুরী
Lordship.
মুভ ইট
Lordship, on that day, I'm in court number 5 and the matter was going on and.
Oh, you
on
are moving it,
21st Yes,
very
Lordship.
without the brief we appreciate that
Lordship, I'm in court number 5 and.
it is filed within time
Yes, Lordship.
On last order, Lordship was directed to file a supplementary affidavit, and that was also ready, Lordship. That is also ready.
No, but the union was, have you given a copy to the other side, union?
Yes, Lordship.
Then their presence.
Lordship,
Supplementary affidavit, we directed
Yes.
you to file?
Yes, Lordship.
So it's not with you right now?
Yes, Lordship.
Let counsel for the appellants, we were adjourning for the day because should we pass it over?
Yes, Lordship, kindly.
But then Mr. Sudipto Majumdar will not be there.
I will inform him.
He's not, probably he's not there till next week. Very well. An adjournment is sought on behalf of the appellant. Let the matter stand adjourned for the day.
Lordship.
You prepare whatever supplementary affidavit. We hope you have given a copy to the union.
Yes, already served, Lordship.
Very
Grateful.
good. Next.
Item number 27.
Yes.
Yes, Sir. Honorable led by Mr. Senior Advocate.
Mr. Bose is there.
Yes,
my lord. Somebody was appearing for the other side.
Yes, Lordship.
Yes, my lord,
Oh, Mr.
I
Bonik
am
is there.
the respondent in this.
Yes, Mr. Bose. What is your
Yes,
matter?
my lord. My lord, your lordship kindly. I'll just take, my lord, 2 minutes of your lordship time, my lord.
Yes.
My lord, this relates to a seizure which was made, my lord, under the GST Act. My lord, I am the consignor of the goods. My lord, I have sold the goods and the goods were in transit, my lord, from Guwahati to its destination in Delhi. My lord, the vehicle in which the goods were being transported were intercepted on 2nd of July 2025 at Jalpaiguri. My lord, at the time of interception, my lord, it was found that the goods were being transported along with tax invoice, e-way bill, transport challan. My lord, why am I mentioning these three documents? Is because, my lord, under the GST Act and the rule, which is Rule 138, my lord, there is a mandatory requirement of these three documents which were required to be carried by the transporter at the time of transportation of the goods. And all three
These
documents
were admittedly there with you, Mr.
admittedly there, and it
Very
forms a
very
part of the show cause notice itself.
Right.
So, my lord, post the interception, my lord, there was a physical verification made. Thereafter, the physical verification report, my lord, which is there, a part of the record, my lord, that talks about shortage of the quantity of the goods from the, my lord, the tax invoice. There was a shortage in the quantity that was detected.
And subsequent evaluation.
And subsequently, my lord, in the show cause notice which was issued, there was an allegation that there is a undervaluation of the goods which were being transported. So, my lord, shortage in quantity and undervaluation. So now the shortage of quantity again does not find reflection in the show cause notice, but in the show cause notice, they say that there is a shortage in, or there is a discrepancy in the valuation of the goods.
Which can be taken care of.
So now, my lord, when the show cause notice was adjudicated, my lord, the final
The
order
quantity actually found, Mr. Bose, was according to them more than what was shown in the tax invoice.
less.
Less, then how can they be
Well,
undervaluation?
but undervaluation. One is the quantity less, and based on one is quantity. Suppose, my lord,
Yes.
the tax invoice provided say 100 metric ton. This
Yes,
was
if
Erica
they found-
nuts. They found upon physical verification, they found 90 metric ton.
Yes.
So there is a, according to them, there is a discrepancy in the quantity to the extent of say 10 metric ton. That is one aspect which was there in the initial physical verification report. Then in the show cause notice, they say that these goods, according to the proper officer, they say that these Erica nuts are usually has a valuation of say 100 rupees per kg, but the tax invoice shows that it is being sold at 80 rupees per kg. So there is an undervaluation of the goods to the extent of 20 rupees.
All right. Yes.
Then they proceed to adjudicate this show cause notice, and a final order is passed of penalty. Now, my lord, the penalty order has, my lord, two components of the penalty order. One is, if your lordship kindly has the GST Act once,
GST একটা আছে
junior. If my lord will kindly take page 1, section 129.
Yes.
Detention, seizure and release of goods and conveyances in transit.
Yes.
So notwithstanding anything contained in this act, when any person transports any goods or stores any goods while they are in transit, in contravention of the provisions of this act or the rules made thereunder, all such goods and conveyance used as the means of transport for carrying the goods and documents relating to such goods and conveyance shall be liable to detention or seizure, and after detention or seizure shall be released. Now, my lord, kindly take 129(1)(a). So, my lord, there is the statute provides for release of the goods.
Yes.
On payment of penalty, A is on payment of penalty equal to 200% of the tax payable on the goods. In case of exempted goods such and such, then my lord, kindly see the last sentence, where the owner of the goods comes forward for payment of such penalty.
Right.
So, my lord, in the event the owner, in this case, it is the owner, my lord, the petitioner is the owner of the goods. When he comes forward, my lord, 129(1)(a) is applicable. And 129(1)(b) would be applicable if it is anybody apart from the owner.
Right. Right.
So, my lord, our specific contention before the Honorable Single Judge was that I am statutorily entitled to release under 129(1)(a).
Yes.
Because
you are agreeable to pay this 200
yes,
whatever.
yes, I
All
am.
right. All right.
Now, my lord,
So
what happens?
then what is it?
Then what
Yes.
happens? Now, my lord, my lord, we had other points, which is jurisdictional point. My lord, we say that the proper officer did not have the jurisdiction to either seize or detain the goods on the ground of, my lord, discrepancy in the quantity of the goods or the valuation. Because that can only be done by a proper officer under section 73 and 74 of the GST Act and by the jurisdictional authority. Now, my lord, in an interstate sale, when it is from one state to the other, where IGST is applicable, intermediate transit, the states through which the goods passes, my lord, suppose, my lord, the goods in this case was passing from the state of Assam to Delhi. So it was passing through West Bengal. So West Bengal was a transit state.
Yes.
So the officers of the transit state under section 2, subsection 21, the proper officer under GST, he has no authority to detain or seize under section 129. This was a point on the ground that the authority or the person who passed the order of penalty had no jurisdiction. But this was my principal challenge in the writ petition. And by way of an interim order, we said we will accept the penalty order. And since I am the owner of the goods, I want to pay the penalty because these are perishable goods. These are Erica nuts. So I want to pay 129(1)(a). Well, the amount which has been assessed in the penalty order, I want release of the goods. And my lord, we relied upon a judgment of the division.
No, you
bench
have
of,
to pay 200% of the tax payable.
my lord, that has already been assessed. If I may just trouble your lordship once. My lord, if I may just trouble your lordship once, if your lordship comes to the penalty order.
Page?
My lord, order of penalty order is at page 78.
Page 86.
Page 78, your lordship will find the penalty order, which is the order of 21st of July 2025.
86.
Yes, 78.
Now, my lord, if your lordship My lord, for the purpose of just the interim order, what we said is, if your lordship will kindly see, I am not troubling your lordship with the rest. If your lordship straight away comes to the penalty portion of the order, my lord, which is at page 86.
Yes, 86.
85 এর last two lines,
Now, my lord, kindly take
last two lines of 85.
paragraph 11.
Paragraph 11.
Para 7.2.
No, my lord, if your lordship will, no, the penalty has been confirmed.
7.2, para page
Roman 2.
85, last.
Roman
Yes,
2
well, no, if
specifies-
your lordship kindly takes first the determination, kindly take once para 7.1, then I'll show your lordship the
Yes.
concluding portion.
Mr. Bose will be just coming back in 10 minutes.
Very well, very well.
Yes, Mr. Bose.
Yes, my lord, if your lordship kindly comes to the penalty order.
Yes, 7.1.
No, my lord, if I may just start from the beginning once, my lord, kindly come where it starts at page 78. And my lord, kindly come to the first page, or in fact, the
Yes.
second page where it says Form GST MOV 9.
MOV 9.
Just the second page.
80.
80, right, at page 80.
80. Yes, MOV 9. 80.
Yes, subject order under 129 subsection 3 of the GST Act 2017, read with
Yes.
relevant provisions of such and such. Then, my lord, kindly see the goods conveyance bearing number such and such was intercepted by a team of officers and booked by such and such Shiliguri CGST Commissionerate on 2nd July. On being asked, the driver of the goods conveyance, such and such, produced the copies of, my lord, may kindly make a note of this, my lord. Tax invoice, consignment note, and number 3 is e-way bill.
Right.
And also, my lord, number 4, Government of West Bengal authorized motor vehicles weighbridge weighment slip. So the goods were, when at the time of interception, the goods were being accompanied by these 4 documents.
Yes.
My lord, pausing here for a moment, my lord, if I may just trouble your lordship once with section, kindly, my lord, take Rule 138, 138 capital A, which should be, my lord, if your lordship, if I could see the book your lordship is, it could be at page 404 of that book.
No, it's a different book, but 138A.
138 capital A. If your lordship is has the commercial bear act, it could be a few pages.
No, this is universal.
Oh, universal. If
We
your
have
lordship,
got 138A. We
very
have
well,
got 138A.
very well. Documents and devices to be carried by a person in charge of a conveyance. The person in charge of a conveyance shall carry 1. A, the invoice or bill of supply or delivery challan, as the case may be. In this case, the invoice, it was being carried, the goods were being carried along with an invoice. Then B, a copy of the e-way bill in physical form or the e-way bill number in electronic form or a map to the radio frequency identification.
49 actually. Clarification. Issued by the board, clarification.
Now, my lord, apropos this, my lord, also kindly take the trouble of looking at a circular which we forms a part of my writ, we did form a part of the writ petition at page 49. My lord, there's a circular at page 49. At page 53, the circular starts at page 49. It's a Central Board of Indirect Taxes and Customs circular of 31st of December 2018.
Column 6.
Yes.
Uh,
And my lord, kindly take column 6 or my lord, serial number 6.
Yes. Yes.
Which says who will be considered as the owner of the goods for the purposes of section 129 of the GST Act.
So either the consignor or the consignee, you are the
Yes, my
consignor.
lord. Here
Yes,
it is
yes.
clarified. My lord, kindly consider the clarification. It is clarified that
We have
if
seen
the-
that. Either the
Yes.
consignor or the other. Seen
Correct.
that. Yes.
So, my lord, now, my lord, if your lordship comes back to the penalty order.
Yes, yes.
Now, my lord, when I was given the show cause, I had given a reply to the show cause. Your lordship can take the reply to the show cause because the reply to the show cause is, my lord, they have reproduced the reply to the show cause in the order itself. So I am not troubling your lordship with the reply
No,
to
no,
the
need
show
not.
cause.
Yes, we'll find.
Yes, yes, my lord, if your lordship will kindly take my reply to the show cause, it is there.
Page 55. Okay.
At page
At page 86,
page 86, my lord, kindly take
8.2.
8
Yes,
point-
86.
8.2.
Right?
97.
My lord, paragraph 8.2, the submission of Ratul Talukdar, proprietor such and such. My lord, it has been quoted, your lordship will see.
Yes.
My lord, kindly take the middle portion of the second page, the quoted portion.
Yes, yes.
At the outset, it is stated, there is a paragraph. At the outset, it
Yes,
is
we have-
stated that I am the owner of the goods.
Yes,
So-
yes, we have seen that paragraph. Yes,
Yeah,
yes.
so I have claimed to be the owner of the good based on the consignment. Then I challenge the other orders that detention is bad,
Yes.
specific goods. I
Yes,
rely
yes.
upon a few judgment. I rely
Right,
upon a judgment of the Allahabad High Court, which says that the jurisdiction of the proper officer under section 129 cannot be at the time of detention based on valuation or based on based on any variation in the quantity of the goods, because that will fall within the purview of section 73 and 74, and the jurisdictional officers will be either the goods Assam or Delhi. So from where the goods originated and the destination. So, my lord, these were the objections that I had raised. Now, my lord, kindly come to the assessment part. Now, my lord, the assessment has been made so far as at page, if your lordship will take paragraph 7.2, calculation of penalty.
Yes. Who is
Calculation
appearing
of
for the other side?
Mr.
Oh,
Bonik, Mr.
sorry.
Bonik is there.
Yes, yes, Mr. Bonik is there.
Yes,
Right.
right. 7.2, kindly take calculation of applicable penalty under A of subsection 1 of section 129. I had shown you, lordship, my lord, because if it is the owner, it has to be A. So, my lord, under 129 1A, they calculate the penalty at 8,31,600. And
Yes,
if
yes.
if it is B, it becomes 83,16,000.
Right, right, right.
So then, my lord, the final order is also the same at paragraph 10.
So you are agreeable to deposit this 200% of this?
Yes, which has been assessed by them at 8,31,000.
Mr. Bonik, what do you say to this interim order? We'll hear the appeal
My
later,
lord,
but the interim order. Yes.
My lord, the petitioner, this
Yes.
appellant is not the genuine person. My lord, kindly have a look into para number 7 of my affidavit in opposition, my lord.
That has not been disclosed. No,
Para 7.
5, 6, and 7. 7 is the relevant portion.
7.
Where's the opposition?
Which is, may I read, my lord?
Yes. Mr. Bush did not have the opposition.
No, I'll
Mr.
tell you,
Bush doesn't
lordship.
have the-
No, I'll tell you, lordship, my lord. The document that my learned friend is relying upon in the opposition did not fall for consideration either in the show cause notice or the final order.
Let us hear,
Well,
let us hear Mr. Bonik. Yes, yes,
well,
Mr.
well.
Bonik. Please continue.
Yes.
Mr. Bonik, yes.
My lord, it is respectfully submitted that it has been explained in para 1 herein above that the transporter of the said consignment is Prime Logistics, who was found non-existent as per physical verification conducted by Guwahati Anti-Evasion Unit, Guwahati CGST Commissionerate on 12/12/2023, in assistance with the officers of Siliguri CGST Commissionerate in earlier UA bill case. Sri Ratul Talukdar, very vital, Sri Ratul Talukdar in his written submission has categorically stated that he is a painter by profession and his address is a residential premises and has never been used for any business activity. It appears that some fraudulent individuals have obtained his documents and misused the same to obtain a fake GST registration. He further requested to cancel this registration at the earliest. From the above, it is evident that someone else in the name of Ratul Talukdar have been trying to move the impugn consignment with intent to evade GST Accordingly, penalty under section 129(1)(b) of CGST Act has rightly been imposed on the claimant of goods. Hence, the contention of the petitioner learned single bench art in law while passing the judgment is not tenable and liable to be rejected. My submission is that the appellant is ready to deposit the amount as per section 129(1)(a), but 129(1)(a) relates to the owner of the goods.
Mr. Bonik, 129(1)(b) also puts the amount as 50% or 200%, whichever is higher.
Yes. Yes.
So it amounts to the same thing, doesn't it?
No, no, no. 129(1)(b), it is penalty equal to 50% of the value of the goods, or 200%, or 200 equal to value of the goods. That means on 83 lakh something plus, 83 lakh plus, and in case of 129(1)(a), that is penalty amount 8 lakh plus. So the in view of this, we have relied upon some judgment of Asian Trading, JJ Traders. It has been mentioned in the order of the Honorable Single Bench. So considering all this, I have objection, my lord.
So
And
therefore, you
my
say
lord,
that if he
another
has to
point
take
is-
up, he is not the owner, then he has to pay that amount, 129(1)(b). At the best,
1B.
that is his best. And
Yes,
second
yes,
ground,
yes.
second point?
And second point is that as per section 107 of CGST Act, the writ petitioner shall have every opportunity to prefer appeal against the order of the adjudicating authority. So, and it is liberty was also given to the appellant.
Right.
In liberty was given in para number 17, my lord, 17 of the single bench order, honorable single bench order. It is mentioned in view of the judgment relied upon by the parties herein, and as discussed above, and also keeping in mind the view of single bench WPA 1240-2025, the petitioner is at liberty to prefer a statutory appeal under section 107 of the CGST Act within 30 days from the date of this order. Period of limitation is extended for 30 days in the interest of justice. It is mentioned, my lord. So, without preferring any appeal, he filed this appeal before this division bench. So, I have objection on behalf of the department.
My lordship.
Right.
If the my lordship permits, may I assist?
My lord, Mr. Vishwaraj is my associate counsel. He is also willing to submit something, my lord.
My lords, may I?
You are appealing for whom?
I am also for
On behalf of the
authorities,
CGST.
my lordship.
He is assisting me, madam.
Yes, what do you want to add, Mr. Agarwal?
My lordship, honorable other side had submitted a judgment of this Allahabad High Court. They have cited, but in page number, my lordship, it gets to the page number 67, para 6 of their MAT application. It can be clearly be distinguished that in that matter, the material was detained on the basis of valuation. In our case, it is not only the case of undervaluation or overvaluation, it is also the case of mismatch between the materials. So that case does not lie in Paresia with this matter, which is lying before your lordship, my lordship.
Mismatch has also been cited as a ground in the penalty order.
My lordship?
Mismatch has been cited as a ground in the penalty order.
Yes, my lordship. Yes, my lordship.
Show us that portion of the order.
My lordship.
Please show us that portion of the order.
My lordship, one minute. Order of 7.
Page 43 are probably the reasons, or what?
In Tokos,
That is a show cause. Yes, no show cause.
Regarding
Show cause.
transporter non-existent, And my lordship, in page
Focus
number
gives-
81, page number 81, my lordship, in the order.
But in the main order, you cannot go beyond the show cause.
No,
You
in
cannot add new
also
grounds.
it is there mentioned, my lordship, in page number,
43.
yes, my lordship, in page number 42, my lordship, if takes
42 or 43? Grounds are given in 43.
my lordship, page number 42, my lordship. The gross weight comes to 49,300 kg.
That is page 43 in our copy.
But in my copy,
Paragraph 3A. Paragraph 3A.
yes, well, 43. Yes, my lord.
Very well. Place it. Gross weight of goods.
Yes, my lordship. There is discrepancy in the material gross weight minus tire weight. It has there is a shortage of 545 kgs. Therefore, the judgment which they have relied upon is not in consonance with the.
Very well.
And my lordship, one point which I just for the my sake I would like to bring to your knowledge, my lordship. My learned senior has cited para 7 of our affidavit of opposition. In page 7, page 12 of that opposition, a statement of the Ratul Talukdar is attached there with my lordship. Page 12.
Page 12, right. Page 12.
Furthermore, if we go through the writ application and the MAT application, my lordship kindly goes through the special of power of attorney which they have attached therewith.
Signature is mismatched.
The signature which they are showing in two special power of attorney itself is not matching with the signature of that statement, my lordship.
Last day. Power of attorney is with the memo
Yes, my lord.
or with the application?
Yes, memo.
Yes.
With the memo.
My lordship, it's in two power of attorney are attached. In page 92 is one power, and in the last page is second power. These both power of attorney
Yes.
signatures are not matching, whereas the statement signature is also not matching. How do it may be determined that the same person is appearing?
Last question, next question. Different আছে.
Therefore,
The
we are
94
claiming
is
that the
from
person who is appearing before this honorable court is not the actual owner, my lordship. They have not come with a clean hands to the court, my lordship.
Yes. Very well. So that is all. Let us hear Mr. Bose again.
No, my lord,
Yes, Mr. Bose.
before I go to that power of attorney signature part, my lord, may I just indicate, my lord, Mr. Agarwal just referred to paragraph 3A, which is a part of the show cause notice. And he says that the show cause notice records that there was a shortage of the quantity of the goods to the extent of 545 kgs. Now, my lord, assuming the show cause notice on this ground, even if it is taken to be correct, my lord, if your lordship will take section 129 and rule 138 capital A, well, this is beyond the jurisdiction of the proper officer under section 129. My lord, if there is any discrepancy to this extent, there has to be section 73, 74 proceeding has to be initiated before the jurisdictional
Which I'm ready to face.
officer. So if that show cause notice is given, I have no other option but to, my lord, face it and, my lord, bring it to a logical conclusion. But under 129, this is not available to them. They have the intercepting authority under 129 has to see that whether there is compliance of 138 capital A, rule 138 capital A read with the circular. In fact, your lordship will find, my lord, what Mr. Bonig had said, apart from this, that the transporter was not available. My lord, the availability of the transporter, my lord, is irrelevant. Because I am the owner of the goods, I am asking for release and I am challenging the penalty order. My lord, identical
No,
facts,
Hmm.
identical facts, my lord, there was a division bench which we
No,
relied
Mr.
upon.
Bose, there was an investigation and apparently there is some doubt as to your identity also. This Mr. Talukdar, Ratul Talukdar, whether you are Ratul Talukdar, actually that's because Ratul Talukdar apparently has raised an issue regarding him being impersonated.
Yes.
I mean, so
Well,
therefore there's a doubt
no,
whether
no,
about your
this
identity.
He also gave his
well,
statement.
may I just say this? This has come
Yes.
for the first time in the appeal. Now, my lord, this Ratul Talukdar's, my lord, existence and whether Ratul Talukdar is the person who has, my lord, filed the objection, this was not there at the show cause stage. It
No,
was
but
not
Mr.
there.
Bose, it is this stage where because you are asking for this 129 benefit here only.
No,
Before the
because-
writ court or before this court first.
Yes, my lord.
Before
I
that, you
am-
did not ask for that.
No, I asked for the benefit immediately after being issued the show cause notice. In reply to my show cause notice, I said, I am the owner, give me release. I am entitled to release. So when the penalty order is passed, which is a order under section 129 subsection 3, there is no remote even observation or any finding by the authority regarding the existence of Ratul Talukdar or the fact that he is not the owner of the goods. Because the law makes it abundantly clear that the person in whose name the invoice is there and who is the consignor of the goods should be deemed to be the owner of the goods unless there is somebody else who comes and my lord claims ownership of the goods. Nobody has claimed
According to
ownership.
them, what section has been contravened here, Mr. Bose?
According to them, my lord, there is a contravention.
According to you, it's 73, 74 at best.
No, I say, my lord, what they are alleging for the purpose or the reasons given by them for the purpose of detention is beyond
Yes.
the scope of 129 and it comes within the scope of 73, 74.
No, 129 merely says contravention of any of the provisions of this act.
Yes. Then,
So
my
what
lord,
is the parent provision according to them
No,
which has
it-
been violated?
my lord, if your lordship will see,
Let us see the show.
No, at the time of detention, seizure of the goods, and your lordship will see in transit. So at the time of transit, the law is 138 capital A, which your lordship has just considered. That the goods must be transported along with these three documents. So this is the scope of examination of the officer under 129. So if he is of the view that there is more than 129, then he has to exercise, the jurisdictional authority has to exercise its powers under section 73. So that will be an exercise of jurisdiction under 73, which is much wider and well, the scope of the examination by the authority is much
So,
wider.
Mr. Bose, we are now hearing you for the purpose of interim order whether we can release the good.
Correct.
Now, regarding that, they have
Yes.
raised an issue regarding your power of attorney filed in this court itself.
Identity proof.
So that's
My-
also an issue.
My power of attorney filed in this court. My lord, I was unaware of this part. My lord, allow me to, my lord, just...
In your opposition, have you taken this point?
They have taken.
No, Mr. Bonik, in your opposition, have you taken this point?
I don't.
No,
There's-
they have not filed any opposition.
No. In the opposition, I don't think
We
they
have
have
filed
taken this
the
point.
affidavit in opposition.
Not
They have
taken, my lord.
But
They have
In
not
the
filed
affidavit in
any
opposition, you have
reply
stated.
to the- They have not filed any reply to the opposition, my lord.
No, you have stated in your opposition this point that there
No,
is
no.
discrepancy in the. It has to be there in opposition. You cannot add new grounds at the time of hearing.
My lordship, we have
No.
already said that the person statement of the Ratul Talukdar has already been attached with the.
No, Mr. Agarwal, we are sorry, we cannot permit you to take new grounds. If it's not in your opposition, you cannot add grounds at the time of hearing.
But we have
Does your
already-
opposition say that discrepancy, point out the discrepancy? Does not.
But we have already stated in our position that the person, statement of
Yes.
the Talukdar, he had already stated that someone has fraudulently obtained his number.
Which paragraph of your opposition? Which paragraph of your opposition?
Para 7.
Para 7.
Para 7, my lord.
And the statement in para 12, page 12, my lord.
Right.
Para 7. And together with para 7, the page number 12, that is the written version of Ratul Talukdar.
Yes, you have stated. Mr. Bose, you have to controvert these allegations.
Yes, I
Otherwise, we
have
cannot
to.
permit you to have this. I will
Correct,
permit you
correct.
time to file reply. We'll extend the time for filing reply.
Very well, my lord. Kindly do that, my lord.
During arguments, comma, learned counsel appearing for the respondents places reliance, comma, inter alia, comma, on paragraphs 7 and 8 of the affidavit in opposition to indicate that the present appellant is impersonating Sri Ratul Talukdar. Since a question of identity of the appellant has been raised, comma, which might be germane even in grant of interim reliefs, for the consideration of whether the goods may be released either under section 129 within bracket 1 within bracket small a. Is it 1?
Yes, my lord.
129
129
within bracket small 1 within bracket small b of the GST Act, comma, on the prayer of learned senior counsel appearing for the appellant, comma, the time for filing reply is extended for a. We are giving you a fortnight, Mr. Bose.
Very well.
If you want to bring
Very
for
well.
a fortnight from date, Fushap, let the matter be listed in the next circuit.
Grateful.
My lord, our names may kindly be noted in the order.
No.
My lord.
No. Why should definitely not. Why should you? Your son has got chance in IIT. My son is reading in class 9, so I am already jealous. No question of recording.
Oh.
Only Mr. Bose's name and Mr. Agarwal's name will be recorded. And password you need.
Yes.
লুকিয়ে ফেলাচ্ছে নাকি?
My lord,
Yes, Mr. Bonik,
now
definitely.
my lord has completed MSc. Oh, grateful.
Congratulations to him. Yes, from all of us. Yes. পাসওয়ার্ড দেখে কি হবে? লোক না থাকলে পাসওয়ার্ড করবে এটা কি? কিছু অমল ইসরায়ের একটা কি পাসওয়ার্ড ছিল?
No, that was
Not to rest. No difficult. পাসওয়ার্ড ডাকো ডেকে তাহলে নট টু করে দিয়ে কি করে?
Matter item number 9.
Yes, madam. Good evening. Please come.
Still in another court? Come back tomorrow then. Tomorrow he has to do it. It was assured that Mr. Mishra has taken time in other courts for tomorrow. So you also take time in other courts and come back tomorrow. On the prayer of the respondent, the matter is adjourned for the day. Please come back tomorrow.
Yes,
Number 10.
It is just not to
Lordship, in
record.
both the matter, Mr. Mishra is appearing.
আচ্ছা same order. এটা কালকে দুটোই সেম হেডিং এ থাকবে, স্পেশালি ফিক্সড. থ্যাংক ইউ.
Number 28.
Lordship, this matter.
Sorry, yes.
Lordship, this matter was appeared on Monday and it
Yes.
was fixed on 16th of June. Lordship, in this matter, Mr. Parthasarathi Debbarman will be appearing physically, Lordship.
তাহলে আজকে এলো কি করে? ব্র্যাকেটে 16 দিয়ে সেটাই করে ওরা ভুল করেছিলাম 16th তো 16th বলছে ফিক্স হয়েছে মুখে বলেছি হয়তো 16th দিতে You are asking for it was already fixed no order is recorded verbally we said
Verbally, it was fixed because the opposite party, the respondent.
you are for the other side
Lordship, I am for the
so you'll keep it on
opposite party,
16th then
Lordship. Lordship, I am praying for next circuit as we got it the brief today. It's a change brief.
so we'll study it over the weekend come back on Monday on Tuesday you are for the appellant
Appellant.
on the prayer of the appellant the matter is adjourned till June 16 2026 come prepared yes
Grateful.
give your appearances both of you.
Item number 29 for the
Appellant petition.
for the Siliguri Municipal Corporation.
for the
Siliguri Municipal Corporation.
Siliguri
Private respondent. There's a private respondent, my lord.
Virtually থাকবে থাকার কথা virtually থাকার কথা
virtually
no he the private
Municipal
মানে
Corporation.
I appear for the
Achha,
private
yes.
respondent but I have been muted not from the
no now I can hear you.
minor
Now we can
Mr.
hear.
Mr.
Both of us can hear you
Mr. Majumdar.
Mr. Majumdar
No, you should come. I have come.
he was muted
No.
must be some
This is difficult sound. Yes, man. Man, what happened?
Mr. Majumdar you are for the private respondent
my lord the writ petitioner
Yes, he-
very well and you are for the municipal yes Mr. Rai
yes.
you are the respondent in the writ petition
No,
the
no,
private
I'm a
respondent.
writ petitioner respondent. I'm a appellant writ petitioner.
Writ petitioner Mr. Majumdar says
No,
he
no,
was the
no, I
writ
appear for
petitioner.
the private respondent was filed by them
in the writ petition also private respondent
no
Yes. Yes.
initial writ petition was filed by Mr.
Mr.
Yes,
He is Mr. Rai he is Mr. Majumdar who
no,
I'm
Mr.
the respondent.
He had filed the initial petition.
I'm the respondent.
Mr.
in the
Majumdar
appeal
was
as well.
the respondent.
The respondent in the writ petition.
Then Mr. Dev
respondent in the writ very well. yes Mr. Rai
What happened? No, my lord, I have challenged a notice issued by the Commissioner of Civil Municipal Corporation. I have challenged the jurisdictional authority of the corporation. If you also kindly, the notice first, you kindly come to page 82. It starts on page 81. Kindly come to page 81, my lord.
81
Yes.
81.
It starts from page 81.
Hmm.
This notice was given 1 and 2 is the Mr. Majumdar's client. Now kindly the contents of the, kindly come to page 82, madam.
Hmm.
I just proceed, then I'll come.
Mr. Majumdar's client was the recipient of this notice
No,
you were the
they're
recipient
the complainant. I'm the recipient.
Achha, very well.
I'm the
Yes.
shelter self-permitted.
right
I just read it, my lord.
Hmm.
The caption is unauthorized construction. This is to notify you that pursuant to a complaint regarding allegations of unauthorized construction erected within the plot being arrest plot number 383, measuring 130 acres, and arrest plot number 3, I am concerned arrest plot number 383 900, measuring 0.24 acres in arrest quotient number 314 Moja, Dabgaon, jail number 200, Rajganj block, Jalpaiguri. The concerned site has also been verified by the technical officials of the office on 31st December 2024. The report as submitted by the technical officials of this office is as hereunder. During inquiry on 31st December 2024, the concerned parties provided the photocopies of sanctioned building plan being number 73 dated 23rd February 2016, which was sanctioned in the name of Shelter Sales Private Limited, my client, petitioner, represented by C. Shumit Agarwal on the piece on parcel land being plot number, there's 4 plots, subject project 383/900. And during inquiry, they stated that they have obtained occupancy certificate which was issued in favor of Mr. Shelters Private Limited. But as per LR Khotiang, submitted by the complainant,
yes please continue
complaining, Firo Orao and Lalu Orao, the present
Sir,
Arwar.
what is the error in the order? You have been directed only to appear,
Because this is-
participate in the
but-
hearing
but-
and impress upon the.
I have jurisdiction because my title, this is question of title has been, I'm showing my lord, I place. Why? Present Arwar of land in question in the name of Tudu Orao and Tenta Orao. Hence, there is a mismatch between the landowner or as mentioned in the sanctioned building plan and present Arwar. And now what is the context of, I just deduce it. First, my lord, one Firo Orao and Lalu Orao lodged the complaint. My Mr. Mundar's client. They say, second point, they say there's an unauthorized construction in respect of plot number, that is 383 of 900. Third, they say the complainant submitted that they submitted the LR Khotiar number of this, the said plot, which is in the name of their predecessors.
Oh, you said it's a title dispute.
Yes.
There is no unauthorized thing
No.
about it.
No,
So if it is not in consonance with the sanction plan, then it could be unauthorized.
Yes, yes.
That is not the allegation.
That's not the allegation. They
Somebody's
say-
name is
they
recorded.
say, this is LR record in my name. Now I can say, they have not said when their name of their predecessors were recorded.
Hmm.
Can you see here, but they very ingeniously written, but as per LR Khotiar submitted by the complainant Firo Rao, Lalu Rao, the present Arwar of the land in question is in the name of Tudu Orao and Tera Orao. When it was recorded? It is recorded in 2024. That was, they have not mentioned, that I'll place it. But this is
But Mr. Rai, please come to section 286.
But 286 is not the relevant. Here, but 286 on the question of the misrepresentation. I'm coming. 286, my lord, they have to form an opinion that I did some misrepresentation at the time of sanction of the building plan. That is not the notice.
Misrepresentation regarding your title, that is what has been here.
If that would be so, my lord, can you see? 286 is, it relates to the misrepresentation or fraudulent statement in the plan or land documents.
All right.
My lord, but the notice was not given under the 286.
But in the garb of this, the municipal corporation does not have the authority to decide title.
Yes, this is my issue.
That is your issue.
Yes. And I say unauthorized construction to section 287. Can you see
287, yes, you are seeing that.
section 287, when unauthorized construction will come, if the building was constructed without plan, in deviation plan, or that sanction was withdrawn.
Right.
So here they have given the notice under the caption of the unauthorized construction. Again, my lord, I am assuming that the question of section 2, application of section 286, they have to form an opinion and indicate that that you have misrepresented at the time of sanction of the building plan and 2016. That was not the case. They said somebody made the complaint, somebody has given the LR record rights, that when it was recorded, that was not given. So on the basis thereof, they have called the call. I said because the fourth should I place it, my lord. I have placed all the documents with the learned judge, the single judge, all there is 5 suits are pending. I just place it all. But after this order, my lord, I moved before the single judge. But you all also kindly come to page 323. 323. রেডি করি My lord.
323. You have got page, the page.
Yes.
Third volume, 3 number volume.
Oh, there's 3 volumes.
3 volume. 150 পাতা করে একটা volume.
My lord, I moved before the honorable single judge. I served the notice of Mr. Majumdar's client. They did not come. Just, my lord, honorable single judge set aside the notice on the ground of can you see paragraph page 325. But the court has decided it.
Then what happened? We have read this order. Yes.
Order. Then Mr. Majumdar's client preferred an appeal against that order.
Right.
The appeal, my lord, they have taken 2 points. They say their client got the copy of the petition, but they did not, they are illiterate, so they did not turn up. So appeal may be heard. And my lord, that's appeal order at page 326, my lord. So my lord,
Remanded.
this remanded, but this is extended, my lord, remand, I should say before lordship. my lord, and the honorable division was remanded, when it's remanded, asks the honorable Singh also to consider the question of section 286 also, my lord. Can you see? My lord, can paragraph 12? Mr. Amoleshwar London Senior Counsel appearing on behalf of the respondent submits that the municipal corporation cannot decide the title of the application. This is a stated proposition of law. However, what is equally true is a person cannot construct building on land that does not belong to him. It is essentially for this reason that section 286 has been incorporated. In the above, this court is of the view that interest justice would be served if the matter is remanded back to the single bench for approval decision entirely on the issue indicated above. So now remitted back. Now, my lord, the honorable single judge passed the judgment. This is at page 411.
Now, single judge has now said that it comes within 286.
No,
although
not
it was
on,
not mentioned.
not on this side.
Not on that.
I have the 2 points. My first point is that this is a question of law. I place all the documents which I place, that is an indicated question of title. I show me your lordship, all the papers, and I place it. And that has been recorded, even my locally single judge decision. Relevant portion, can you paragraph 416.
Give the paragraph number.
Paragraph 11.
11.
I just placed. The writ petitioner have also filed their written statement notes detailing their case as made out in the writ petition, and hence further attention to prove their title in the disputed property by setting details in the method of transfer before the writ court. Considering all the facts and the materials on record, and also keeping in mind the direction of the division bench, it is for the court to ascertain as to whether input notice issued by the are in accordance with law. And the division has not said. Division said that remitted back to the matter. Can we consider both the points and decide it? One point is whether is there a title is involved, and secondly, if section 286 is applicable or not. This is the division has not said. This is now keeping the input notice issued, but admittedly the authority concerned has only directed the petitioners to produce relevant documents to decide the complaint made against the petitioner regarding unauthorized construction made prima facie on the property which belongs to another person, and most of the person belonging to tribal community and land being tribal land. But this is absolutely incorrect. But this is an issue pending from the now is a division bench. I'll place it. What is a tribal land or not? Because what happened, my lord, I just placed all documents, my lord. What happened? There's a recording the arrest records. Private respondents challenge it, and that is recorded in their name. Then the paper appeal before the estate acquisition appeal, lordship knows it. That was allowed. By this time, they sold the lands to many peoples, and then before the tribunal decided the matter and said, no, don't record their names until the suits are all suits are. I'm showing. Then the tribunal judge is also before the writ court. This is now pending with Justice Division Bench, Justice Shampa Sarkar. The issue raised there that the London DLRO has failed to appreciate the report of the BLRO. BLRO said that serial number, the DAG number 23 in the CS record was recorded in the name of Banuri Law, from whom I got it. But these are but I can't say these are pending. My point is that on the basis of only recording of this LR records, but that was not done properly. Court said, no, I will not go to these questions. This notice, our challenge and notice is, if the notice on the question of unauthorized construction, then my lord, it touches the title. I'll show all the papers. On the question 286, the commission has not formed an opinion to show that, no, yes, this is your misrepresentation. And this is my 2 points. And I just placed all the documents.
No, need not at this stage. Let us hear Mr. Dhot, then we'll come to Mr. Ojala.
I'm letting Mr. Subject to is what I'm stating that actually this building plan was granted in the year 2016. It's a huge chunk of land.
So what?
At that point of time, no complaint was raised.
Even if there was pending suits, disputes, these complainants who are complaining in 2024, at that time, with their eyes wide open, they were seeing the building.
But
Whatever.
you issued the show cause.
Yes, we issued the show cause. Thereafter, in the writ petition, when these notices were challenged before the writ petition, we had taken a fair stand that no purpose.
Let us hear Mr. Mujumdar then. The unfair stand, let us hear that.
Yes.
Yes, Mr. Mujumdar.
At that
Understood, your stand has been understood.
that
Yes.
time, no complaint,
Very
no
good.
nothing. Subsequently, they
15 minutes left still
Yeah.
for lunch. Yes, yes, Mr. Mujumdar. Mr. Mujumdar, you are again muted. We don't know, sir. There's some.
I just want some, Mr. Mujumdar, there was,
Let Mr. Mujumdar speak then. Yes, yes, Mr. Mujumdar.
It is a classic example of respondents challenging its own action. Now,
Ye-
now, please
yes.
come to paragraph 6
Something's
of the writ
happened.
petition. I am not at all on the title question. Paragraph 12 of the coordinate bench order in the earlier round has already made it clear that the municipal authority cannot go into the question of title. Paragraph 12
Right,
of the order
right.
clearly records that.
Yes. Para 12 of the writ petition, where do we find it?
No, paragraph 12 of the stay application, paragraph 6
Stay
of the
application.
stay application
Yes, yes. So let us find it.
at page 6.
The application. 6 এ তো অন্য জিনিস।
Paragraph 6.
I'm sorry,
Paragraph
page
6 is not-
8, page 8, page 8.
Yes, paragraph 6.
Not
Paragraph
very
6,
happily
yes.
legible, but it's page 8.
Yes.
It cannot be said. It cannot be said in any manner whatsoever that the appellants made any material misrepresentation or fraudulent statements, particularly in respect of record of rights of RS plot number so and so at the material point of time of submission of the building plan before the municipal authorities for sanction. The documents furnished by the appellants for sanction of the building plan are still valid in the eye of law.
Yes.
Now, not apropos this scope, please have a look at page 89. Whether there has been a misrepresentation of fact or a fraudulent approach in obtaining a building sanction plan is a question of fact which is required to be gone into. Please come to page 89 now.
Yes, 89.
But I may read it from 88. This is to notify you that pursuant to a complaint regarding allegations of unauthorized construction erected within the plot being RS plot number 383 measuring so and so acres and RS plot number 383 by 900 measuring 0.24 acres in RS.
But this is another notice was challenged by them.
First to notice, subsequently,
It's a
This
continuation.
notice was also challenged.
subsequent
Continuation.
says they can take steps.
It's a continuation.
Sorry, yes.
Has also been verified by the technical officials of this office on 31st
This
of
is-
December 2024. The report as submitted by the technical officials of this office is as hereunder. During inquiry on so and so, the concerned parties provided the photocopies of sanctioned building plan number 73 of 2016, which was sanctioned in the name of shelter represented by so and so on the piece and parcel of land being plot number 383 of 900. Then other plot numbers are also there. During inquiry, they stated that they have obtained occupancy certificate which was issued in favor of shelter sales, but as per LR Khatian submitted by the complainant, the present ROR of the land in question is in the name of two other persons, the tribal people. Hence, there is mismatch between the landowner as mentioned in the sanctioned building plan and present ROR. Now, pursuant to the order passed by the Honorable Calcutta High Court Circuit Bench, in connection with the aforesaid writ petition, all the parties are again directed to appear before the undersigned along with copy of the approved building plan and other relevant documents, if any, on 10th June at 12 o'clock, failing which the aforesaid matter will be decided ex parte and appropriate action will be taken under the relevant sections of the West Bengal Municipal Corporation Act. Now, my lord, this is followed up by a direction with closure of the hearing at page 92.
But no, actually,
Pursuant to the order dated 19th May 2025 passed by the Honorable High Court at Calcutta,
in connection with the aforesaid writ, a hearing notice was issued and served. The notice directed all parties to appear. In compliance, a hearing was conducted on 10th June in the chamber of the undersigned in presence of officials from the building cell. During the course of hearing, the addressee numbers 1, 2, 3, 4, 5 and 12 appeared and submitted their respective claims and counterclaims for consideration. The opposite party further prayed for additional time to file the written statement along with other relevant supporting documents. The prayer of the opposite parties hereby considered and allowed. All the parties are directed to submit their written statement along with relevant documents on or before 17th June. All the parties are hereby directed to act accordingly. A copy of the recent order be immediately sent to the concerned section department and the necessary parties for immediate compliance. So all the corporation wants to invoke is section 286. Please have a look at section 286 as the statute now stands.
Yes.
In running page number.
Yes.
Molu শেষ করুন।
414. I mean internal page 4 of the order. Have your lordships got that? Internal page 4. Paragraph 10.
Just give us half. Yes, yes.
But section 286 is quoted there. Power of
Yes.
the commissioner to cancel permission on the ground of material misrepresentation by applicant if at any time sanction to erect any building has been given and the commissioner is satisfied that such sanction was given in consequence of any material misrepresentation
Yes, sir.
or fraudulent statement contained in the plans, relevant section or specifications or land or any material particular submitted in respect of such building. So, the scope of investigation into the affairs of or the possible aspect of misrepresentation is spelled out in the provisions being relevant section or specifications of land. It's not a question of
Specifications of land, there is no dispute regarding specification of
that's
land.
the question
dispute
which the
is-
authorities on inspection have found to be prima facie
But
untrue.
Mr. Mojumdar, the wrong recording or correct recording, record of right, that is to be looked under the
Different
land reform
provisions,
Act.
the
And
statutes are
title
going
dispute by civil court.
Right.
But
Now, not
how can
whether
this come within?
in the name of
What is the
393
authority of the
by 900,
municipality?
whether in the name of 300, whether in the name of representing that I am
Yes.
constructing on 393 by 900, not construction has been obtained by disclosing 393 by 900 by A as a land. That's the scope of inquiry being made.
Look, that is
Paragraph
not the
12
notice.
Paragraph 12 of the previous coordinate bench judgment specifically says that the commissioner cannot go into the question of title.
Right.
So the question
But
of
this
title.
mismatch. No, the mismatch
the-
he was now they are citing a mismatch, but the
Yes.
mismatch as given in the second notice also.
Yes,
That is in respect of, just see that.
Please
You
come
have
to-
made a complaint. ROR is page 88, 89.
Yes. Yes.
Hence, there is a mismatch between the landowner as mentioned in the mentioned building plan and present
Yes.
ROR. First of all, ROR is not document of title.
No, it's
Secondly,
a
how can the municipal commissioner go into
possessory
it?
right. Not, I am not going into the question of title or not the recording because those are
Yes,
subject matter of
yes.
different adjudicatory process. Suits
Yes,
are
and
pending.
those are pending also.
Right. But I am not into that at all. But what has been
Hmm.
asked to be explained is in terms of 286, please come back once again to the language employed in 286
Yes.
at paragraph 10.
26, yes. Or any land or any material particular submitted in respect of
Specification.
such building.
Specification.
Specification or yes. No, fraudulent statement contained in the plans, elevation
land.
section or specifications or land.
Right. So whether the land described in the plan with regard to
Yes.
which the specification was made and sanction was obtained,
Specified.
that is being questioned or not looked into. But why does my
No.
learned friend's client have to preempt this
Especially the
process?
separate word.
No, but this notice is without jurisdiction, Mr. Mujumdar.
No,
It's palpably without
today-
jurisdiction.
Today there is a question of misrepresentation. But a misrepresentation is essentially a question of fact. Not law is well settled.
But
that
where
we
is the
cannot-
misrepresentation here? Where is the allegation of misrepresentation? Here it is during inquiry, it is found that LR records are in the name of a different person.
Right. So not there is a
They
possibility.
said that they are owners.
So there is a.
Yes.
They are saying they are owners. There is a mismatch which has been asked to be explained.
No. LR
come-
records.
That is only
cannot
possessory
be.
right. That is only possessory right.
No.
But I'm not saying that
Municipal-
that's a title right. Now please come to the language in that particular section 286 once again. But how can my learned
Yes, we have
friends
seen the languages.
preempt this? Not
No,
please see,
Mr.
287 unauthorized construction subject to the provision of 266. If the
Yes,
commissioner
yes,
is
286 it's subject. So 266, yes.
is that the has commenced without
266.
should be
No,
286.
here they have got a sanction plan. It was
Right.
issued by the municipality.
Right.
Now, there is no discrepancy in that alleged also. I mean, in the show cause notice at least.
Lordship kindly
So
recollect
only
section
mismatch-
397, section 397 of the KMC Act. Similar
Yes.
provision. Plan obtained, a sanctioned building plan obtained, at any time the municipal commissioner can revoke that plan. If he is satisfied that there is a possible misrepresentation or fraud, the language used in 397 is fraud also.
But where is the misrepresentation here? They have
That's what-
said that they are owners. They have obtained occupancy certificates.
Right.
Now they produce occupancy certificates. They say prima facie they have shown some ownership document. And if ownership is in contention, that is subject is in other proceedings also regarding the LR records of right.
Not the question
So
of
the
title.
municipal commissioner cannot decide.
No, no, no.
What
he
will
will
the
not-
municipal commissioner decide?
My
So the municipal
complaint.
commissioner then has to decide that LR records is in the name of somebody else, therefore they don't have title.
No,
How can
no.
it be done?
My complaint is not on that. I say that by representing 383 by 900 as your plot of land, you have misrepresented this fact and obtained plan for land in excess of this.
That is not the show cause.
No.
This
he
show cause
says
notice
that
cannot
there is a-
survive then.
Please come to the report which has been quoted in the order, in the show cause notice. Not a show cause notice, a notice of
No, but-
hearing. During inquiry on 31st December 2024, the concerned parties
Yes.
provided the photocopies of sanctioned building plan being number 73 of 2016, which was sanctioned in the name of shelter, represented by so and so, on the piece and parcel of land being plot number 383 by 900, 383 by 901, 383 by 902, Khotian number 343, 344, 349. During inquiry, they stated that they have obtained occupancy certificate which was issued in favor of shelter. But as per LR Khotian submitted by the complainant, the present ROR of the land in question is in the name of Tudu Orao and Tenta Orao. There is mismatch
No.
between the landowner as mentioned in the sanctioned building plan and present ROR.
The commissioner cannot go into the ROR and decide this issue on that.
No, the ROR is presently before the tribunal.
Yes. This is
Title
beyond
over-
jurisdiction. 286 does not cover this.
Now please come to paragraphs pages 10 to 12 and 14 to 15 of the stay application.
Whatever they have written in the stay application, Mr. Mujumdar, that is not material. We are looking at the notices themselves and the judgment of the learned single judge. Learned single judge proceeded on the premise that 286 non-mentioning the caption is not fatal. We agree with that. But this is not covered by 286.
No, 286 only operates in the
Learned single judge, Mr. Mujumdar proceeded on the premise that this is tribal land there. This was entirely beyond
No.
jurisdiction by the learned single judge.
tribal
also.
land issue. That tribal land issue may not be not relevant because in the
Cannot be.
Correct. No, that is something.
Even independently, this is beyond 286. Mr. Mujumdar, get your disputes resolved by the wherever it's pending, writ court or wherever.
No,
Is there
Mr.
a civil
Rajiv,
suit?
No, I said there are 4 civil suits.
Four civil suits.
Those
Great.
civil suits are from. This will go on for years. No, we know not.
I show you.
Please come to page internal page 5. Please come to internal page 5 of the order.
Yes.
The first line of page 5 is misrepresentation or fraudulent statement contained in the plans, elevation section, or specifications or land or any material particulars. So what? The specification of land in the
Specification of land is not in doubt, Mr. Mujumdar. What is in doubt is the land specified by them. That is recorded in the name of somebody else. It's not an issue of specification of the land. Specification could be boundary dispute. Specification could be that is like something like that.
Whether by
Here you
naming
are not-
383 by 900, you are spilling over 383 by 901.
That is
That's
not even the
specification
show
of
cause
land.
notice. The show cause notice said the self-same land for which you have produced your occupation certificate, those are recorded in the name of somebody else. There is
No.
no dispute regarding specification.
No, the
Specification same. Recorded in somebody else's name.
It's not
In
only
our name
recording.
first,
It's not only recording because not the specific case
That
run
is
by
the show cause.
the specific case run by the writ petitioner appellant is he is part owner of this land. That's not whether being a part owner of this land, he has obtained sanction plan
But
by
this show
representing
cause notice, Mr. Mujumdar, this show cause notice cannot serve. Neither of the show cause notices. Notice for mismatch or, sorry.
Then direct the commissioner to proceed in accordance with law, because
No,
not,
no,
there is a,
we are setting aside the show cause notices, therefore everything else goes consequential.
because not the elevation section.
This
or-
is without jurisdiction, palpably without jurisdiction. This is not under 286 does not, we cannot give so much power to the commissioner,
No,
municipal commissioner.
Specification of land is one of the factors for.
Where is the question of specification? Specification is not in doubt. The ownership is in doubt. Recording in record of rights is
Ownership
regarding the
is-
same specified land.
Ownership is with regard to 383/900. That is in doubt. Nothing beyond that. Now, not, if I say that 383/900 comprises of 10 acres, and I obtain plan from the municipal commissioner by saying
That is
383
that is not mentioned at all anywhere in the show cause notice.
No,
What you are
that's
saying now?
no,
It's beyond the
show
show cause notice.
That's why the investigation is. That's why he has been asked to come
No,
with the
it
document.
cannot be a roving inquiry, Mr. Mujumdar. It cannot be a roving inquiry by the municipal commissioner to ascertain whether that land is recorded in somebody else's
No,
name.
it's not
That's why they have
recording.
title.
Not the admitted case of the writ petitioner is 383/900 is not the entire plot of land. It's a part and part. It's a part of the land.
Maybe, but the show cause notice only says that obtained occupancy, they obtained occupancy certificate, but as per LR Khotian, it's recorded in somebody else's name. So that's why inquiry. That is the mismatch. There is no mismatch here.
Mismatch is with
Mismatch
regard
between
to the-
LR and no.
That's the recording of.
No, Mr. Mujumdar,
rights.
sorry.
But not
No,
the
no.
specification of land comes within the jurisdiction of this person, the
No,
municipal
no, no.
commissioner.
This is not specification.
Not he. May I show not just two paragraphs from the stay application? Just two paragraphs. Please
No,
come.
why should you look into the stay application? Forget the stay application. We are looking at the notice itself and the judge's order. Learn
Right,
judge's order.
because your lordship is looking into the case of the writ petitioner from the anvil of the title dispute raised.
We are looking only from the anvil of the ambit of the connotation of these notices and the single judge's order. Nothing else.
Yes. Now, your lordships are proceeding
No,
on
no,
the
no.
basis that this recording of rights, the record of rights is in the name of Mr. Rice's client.
No, we are not proceeding on that basis. We cannot enter into that. We are saying that corporation could not enter into, the municipality
Corporation-
could not enter into that.
Corporation is not entering. Please come to paragraph
No.
paragraph page 10 of the stay application. Only once. Page 10 and page 14.
Yes, page 10 and 14.
Yes.
Yes.
Paragraph 14 at page 10. One
Yes.
Orao was the original owner as per CCS Khotian number so and so belonged to tribal community
This is
as
not
per
No, we cannot
other
enter into
settlement.
these questions, Mr. Mujumdar. We cannot enter. Neither can you nor can Mr. Rai's client let us take us into through these.
No,
These are we won't enter into the merits of these.
I am
Neither
I am
could the
sure-
commissioner.
What would the specification of land in the context of section 286 mean?
No. We are looking at the show cause notice, Mr. Mujumdar. There is no dispute regarding specification of the land.
That your
No
lordship,
dispute regarding it.
that your lordships are probably persuaded to preempt in view of not in even in the teeth of page paragraph 14.
No.
No,
Sorry.
there is a title dispute.
No. It's a title dispute.
Right.
It's a title dispute.
Now please
At
come to
best,
paragraph
at best,
14.
at best regarding recording in the records of rights, and which is also sub judice.
That's right. Now, I'm not, as of today, there is an order existing in favor of my client, but not paragraph 14 himself, he says that he is owner of part of this land and the specification is being looked into by the commissioner.
Whatever he says in his stay application, Mr. Mujumdar, we cannot look into that. We are looking at the main matter. Heard learned counsel for the parties. Fullstop learned senior counsel appearing for the appellant argues that the learned single judge traversed beyond jurisdiction in construing the impugned notices issued by the Siliguri Municipal Corporation to have been issued under section 286 of the West Bengal Municipal Corporation Act 2006. Fullstop, it is contended that the nature of the dispute raised as reflected in the impugned notices pertains to title dispute, which could not be gone into by the Siliguri Municipal Corporation. Fullstop, next para. Learned counsel appearing for the Siliguri Municipal Corporation submits that although the impugned notices were issued by the municipal corporation, the corporation now takes a stand that the private respondents sat tight over the matter for an inordinate period during the construction being made and were and came too late in the day in raising the challenge. Who sub next para, learned senior counsel appearing for the private respondent submits, comma, by placing reliance on the language of section 286 of the 2006 Act, that the dispute, that the complaint lodged by the private respondents and the ambit of the impugned notices pertains to mismatch in specifications of the land over which the construction was sought to be made. Push up next para, learned senior counsel relies on the specific language of the said provision and argues that in the event the commission is satisfied that sanction was given in consequence of any material misrepresentation or fraudulent statement contained in the plans, comma, elevation section or specification or land or any material particulars submitted in respect of the building, comma, it may cancel such sanction. Push up, learned senior counsel further adds that since it is found that the land in question is recorded in the records of right in the name of certain other persons, and the sanction plan was obtained in respect of a plot different from that for which it was purported to be obtained, comma, the matter relates to a dispute, a question within the contemplation of section 286 of the 2006 Act. For sub next para, we find upon hearing learned counsel, comma, we find from the impugned judgment that the learned single judge went into the question as to whether the construction, whether the construction is being made by the appellants prima facie on property which belongs to another person, and more so the person belonging to the tribal community and the land in question being tribal land. Push up, the learned single judge further found that the present land being tribal land, comma, the respondent number 3 had also found prima facie a mismatched land, comma, in the name of the landowner as mentioned in the sanctioned building plan and ROR, and as such called the parties for a hearing. Push up next para. However, comma, with respect, comma, we differ from the said view in view of the specific language of the two impugned notices, comma, respectively dated December 27, 2024 and June 3, 2025. Push up next para. In the first, in both the said notices, comma, the sole premise on which those were issued is that the appellant obtained occupancy certificate issued in its name, but as per LR Khotian submitted by the complainants stroke private respondents, comma, the present ROR of the land in question is in the name of Tudu Orao and Tenta, TENTA Orao. Push up, the said show cause notices proceeds to observe that within double inverted, hence, comma, there is mismatch between the land owner as mentioned in the sanctioned building plan and present ROR, double inverted close, push up. Next para, the said question squarely pertains to the recording in the records of rights, comma, which comes squarely within the purview of the land acts, comma, such as the West Bengal Land Reforms Act and stroke or the West Bengal Estate Acquisition Act, and falls within the domain of the concerned authorities under the said act. Push up, in fact, comma, we are apprised by learned senior counsel for the appellant that already proceedings are pending in that regard before the appropriate court stroke authorities. Push up next para, that from a different perspective, comma, the question also pertains to the title of the parties, comma, since the plinth of the show cause notice is that the names recorded in respect of the subject land in the records of rights are different from that of the appellant. Push up, apart from the well settled principle that records of right, entries in records of rights do not determine title, comma, the said matter is also sub judice in different civil suits before competent civil courts. Push up next para, The limited conspectus of section 286, section 286 of the 2006 Act is quoted below. Eta quote kore deben. The limited, next para, the limited conspectus of the said provision is attracted when there is material misrepresentation or fraudulent statement, তারপর double inverted, contained in the plans, comma, elevation section or specifications or land or any material particulars submitted in respect of such building, double inverted close, full stop. Next para, the question raised in the show cause notices, in the impugned show cause notices, does not pertain to any of the above, full stop. The mere double inverted, the mismatch, double inverted close, between the entries in the records of rights and the occupancy certificates on the basis of which sanction plan was granted cannot be termed as a misrepresentation or fraudulent statement in the plan, comma, elevation section or specifications or land or any material particular. Full stop. Next para, if the show cause notice is to be construed under section 286, to be under section 286, comma, it also has to be necessarily interpreted that the said provision takes within its ambit adjudication of title and or the adjudication in respect of veracity of entries in the records of rights, comma, which fall within the exclusive domain of specific authorities under specified acts. For sub next para, it is entirely beyond the jurisdiction of the municipal corporation, comma, as also held previously by a learned single judge of this court in connection with the matter in a previous round of litigation, comma, comes within the purview of our title dispute. Which sub next para, in such view of the matter, comma, the impugned notices were issued completely without jurisdiction by the Siliguri Municipal Corporation. Full stop. Accordingly, comma, with respect, comma, we differ with the view of the learned single judge on such count. Full stop. Next para, we would be failing, this court would be failing in its duty if it did not mention the concern of the learned senior counsel appearing for the private respondent to the effect that the hearing has already commenced in terms of the impugned notices, and as such the points taken here could be canvassed before the appropriate authority. So next para, however, comma, since we have held that the impugned notices were issued without jurisdiction and were vitiated on such count, comma, anything done incidental thereto or in pursuance thereof is automatically vitiated. Full stop. Hence, comma, there is no requirement to relegate the parties unnecessarily to a futile hearing before the authorities. Full stop. In such view of the matter, comma, no useful purpose would be served in keeping the appeal pending. Accordingly, MAT 44 of 2026 is allowed on contest, comma, thereby setting aside the impugned judgment dated March 2, 2026, passed in WPA 883 of 2025, as well as the notices impugned in WPA 883 of 2025 and WPA 897 of 2025. These are the only two notices, comma, respectively, dated December 27, 2024 and June 3, 2025. Full stop. Next para, consequentially, can
only one humble submission, not this, not there were
one second, Mr. I'll come back to you. Condonation was allowed previously.
Yes.
Can 2 is only remaining.
Yes.
Accordingly,
Stay
can 2 of 2026 is also disposed of in the light of the above observations. No address to cost. Yes, Mr. Mujumdar.
Not your lordships are interfering only by reason of the language employed in the show cause, in the hearing notices. Now, my lord, there were 2 or 3 allegations contained in the notices. This may not be taken as a complete closure of the allegations laid before the commissioner. Because
right
your lordships
there.
are interfering
We'll add a
because
line.
of the language.
We'll add a line. It is made clear that the impugned notices were set aside on the ground of jurisdiction, and this court has not entered into the merits of any of the allegations made in the said
Yes,
notices and stroke or by the private parties against each other, and it will be open to such parties to canvass such questions before the appropriate forum stroke court.
Yes, yes.
That is sufficient, Mr. Mayor.
Good.
Thank you. Urgent
Yes,
certificate.
I also said it.
My lord, if
Yes.
your lordship kindly allow me to make one submission, my lord.
Yes, Mr. Shara.
My lord, this bench will not
Another
see the
one.
PPL, my lord. My lord, item number 31 is some urgency. Can it be taken up tomorrow at the priority basis?
31, what is the urgency, Mr. Shara?
Altogether, we are enjoying the interim order. The petition has been dismissed on the last date of the summer vacation. That's the whole difficulty.
No upgradation, Mr. Shara. We have refused others also. Let us hear the matters as they come. Because there are other fixed matters also.
245
No upgradation, sir. No upgradation.
It is
Yes,
not taken
yes.
up, my lord. True course 5, I have to make payment. True course. That's the only difficulty, my lord. Last day of vacation.
Sir.
If it's not
No,
taken up,
sir.
they have already issued
No, let
another
us see if we
notice.
can reach otherwise. Otherwise, no upgrade, no further upgradation. Yes, yes. No upgradation, sorry.
Good.
Number one.
Key correction. Huh? Oh. In the order dated June, শঙ্কর শুভ্র তুমি এটা প্রচুর ম্যাটারে করেছো। ছটার বেশি, ছটা ছাড়িয়ে গেছে। In the order dated June 8, 2026, the date was erroneously transcribed as 06.08.2026, full stop. The said date be read as 08.06.2026.
Appeal number two.
This is the second occasion when none appears for the petitioner at the time of call. Full stop. As a last chance to the petitioner to move the matter, the same is adjourned for the day.
Number three.
Milord, I am opposing, Milord, item number 3.
Where is he?
I am opposing, Milord.
He's not appearing. What is the matter about?
Milord, the matter
This item-
pertains to Milord arising out of an arbitration proceeding where Milord.
Mr. Dasgupta, you are for whom?
I am for the OP, Milord, opposite party. And Milord, the claimant before the learned arbitrator.
No, Mr. Shiv Shankar Banerjee is supposed to appear for the petition. He's not there.
Yes, he is for the petitioner. But the thing is that Milord, the pendency may cause Milord difficulty to the learned arbitrator, Milord.
This is against what?
Milord, order passed by a learned sole arbitrator, Mr. Amitesh Banerjee, where Milord he
No,
had
227.
is not maintainable, first of all. And number secondly,
What
Milord,
was done by the impugned? What is the impugned order?
yes,
Mr.
yes,
Dasgupta?
the impugned order is that Milord he has disallowed Milord a filing of counter claim after Milord issues are framed and Milord evidence filed. Now Milord the issue is no more Milord in res integra Milord due to the Milord Ashok Kalra judgment, where Milord Supreme Court has repeatedly said that Milord after framing of issues, Milord no counter claim cannot be allowed in any manner whatsoever. Milord, I can show the Ashok Kalra judgment, Milord, before your lordship, Milord, if my lord feels.
No counter claim cannot be allowed.
It cannot be allowed. It's at best till the framing of the issues. At best. And Milord, the 3 judges bench. Milord,
No, but I'm in doubt whether this 227 is maintainable at all.
no, 227 is definitely not maintainable. 227, Milord, is not maintainable from an order passed by learned sole arbitrator. Then Milord, a Pandora's box will be open if the Milord, if this
Yes.
is held to maintainable.
Right.
Then Milord, it is barred under section 5 of the Arbitration Act. No intervention of the
yes,
judicial
absolutely.
intervention.
Right. Yes.
Clearly
what you
barred.
say? Thought passover, Mr. Dasgupta is appearing virtually. How can I make him wait for He cannot wait indefinitely. He should have been here, Mr. Banerjee.
No, Milord, they took time on the last day also, Milord. It was item number 3 day before yesterday.
What technical issue? His name is not appearing. Shiv Shankar Banerjee ki
No,
contact
no
করছে,
technical
চেষ্টা
issue,
করছে?
Milord. We are all having a Milord nice.
No,
video,
he's not
Milord,
there online at all. No technical issue.
He's not there. No, Milord, this is not at all maintainable.
No,
Milord,
this is not
dismissal,
maintainable.
that's
I'm
gone
dismissing
on.
it.
This is not maintainable. Kindly don't entertain Milord for a second.
No, Mr. Dasgupta, she'll be embarrassed. Let us pass it over for the time being.
Milord, passing it over for the time.
please. Time being is 10 minutes.
Very well, I'm there.
Approximately
I'm there.
10 minutes. Let us see.
Very
Yes,
well, I'm
yes,
there.
yes.
I'll come back. Very.
Next.
Appeal number 4.
Yes. Right. What is this suit for?
Primary is filed for consummation of that.
confirmation of the title, something means the person should be. Like,
Only title, not possession.
confirmation of possession, no title.
Confirmation of possession only. Okay, let us see the plaint. Where is the relief? Aji, yes.
And it comes to
Yes. Page 40. 40. 40. 40 is prayer. Oh, no, title also. Confirmation of exclusive title first. No, first also. Confirmation of plaintiff.
exclusive, yes, right title.
Peculiar, couched in a peculiar manner, but declaration is also there. Yes. So, on what ground did you seek rejection?
It's not the primary manner. Subsequently amendment manner to this. I'm coming because hereafter manner I find and the other side. I keep file an order. It's under order 26. Although that order is set aside with this honorable court, as well as another report filed by the Malak Commission, but it has some little importance.
No, we cannot look into anything else from the plaint. 711, we cannot look into anything else. You know that.
Yes. But
You reject, short for rejection on what ground? No, we cannot look into that.
because for commission report says commission is not in progress. That is one thing. I'm not going to that.
That can be framed as an issue in the suit.
Yes. But it is several principle of law that the three plaintiffs they are accompanied by this documents which he wants to learn. And this one, really one of conspiracy it is missing.
CPC te dao to hame. CPC. Thank you. But what was not filed according to you?
With the plate, there's no abatement regarding other compliance of order 714. The plaintiff wants to rely on the following documents. On the basis of which another trial may proceed. Because it is not mandatory input, because in subsequent state, plaintiffs cannot be allowed to.
And that is not a ground under order 711.
It's a Supreme Court of experiment that can be looked into in by deciding order 711. Because it's also part of my cause of action.
You can file an application for interrogatories for discovery. You can always file an application for discovery or interrogatory. Why 711?
When plaintiff paid, when the order is set aside with the commissioner by this honorable court, immediately my lord, they file an application for my lord amendment of the plea. And my lord, they have taken it briefly, that is that they are for recovery of possession. My lord, kindly stands to that new plaint which is appearing on 33. In that plaint also, plaintiff does not file.
What has
Some
done?
document has to be filed on the basis of who is a trial will proceed.
That is not a ground under order 711. Sorry, no.
Well, kind of consider one judgment that has not been considered by the honorable Planet Court below us.
Cite it.
Yes, 2012.
That was considered. I find it from the impugn order.
Yes, but that now kind of seems what the Planet Court has said.
But let us see the judgment. Yes. That is considered, not that not considered. Yes. Any particular paragraph, Mr.
17.
17. Yes.
The case on hand of the respondent to get a degree for specific purpose that there is sufficient necessary authority under the power of control. Order 7 Rule 14 mandates that the plaintiff has to produce the document on the which the cause of action is based. Therefore, he has to produce the power of action when the plaintiff is presented by him, and if he is not in possession of the same, he has to state as to the inputs by the plaintiff. In the case on hand, only the agreement between the plaintiff and the second has filed with the claim. Order 7 Rule 14(1). As rightly pointed out, the latest senior counsel for the applicant, he is not in possession of the power to raise a document. You have to find a registration copy of the same. Again, for not filing the registration copy of the power, order 7 Rule 14(2) instead of the registration, that is a different one. So, primary thing is that is the one motive of
Here, the main appeal was decided that the suit decree was passed. In this case. No. Let us see. Acha, order 7 Rule 11 was. Acha, acha.
As a judgment, I think one also said
Hmm.
that by deciding order 7 Rule 11, order 14 has to be.
But this was taken in the.
It cannot be put in dark.
In the context of that, it was held by the Honorable Supreme Court that it has to produce in a suit for specific performance, mandates that plaintiff has to produce documents on which the cause of action is based.
Yes.
He has to produce such and such.
Yes, that is the mandate. He has to produce. So it relates to Mother Order 7 Rule 11. So in that manner, it was opens the floodgate of litigation if any document, even manner no deed has been produced.
Let us see where he has in his plaint he has relied on this, on what document?
He has not said anything.
No. Order 7 Rule 14. Order 7 Rule 14 says if a plaintiff sues upon a document or relies upon a document, then see if he has not relied upon a document or sued for a document, then his case will fail. The plaintiff case will fail. He won't be able to. No, not at 711 stage. He should be given an opportunity to adduce evidence in support of his case. And you can always ask for inspection or discovery. No scope of inspection here, as you rightly point out, because no document has been relied on. He has not relied on a document. In that case, it was a suit for specific performance. He obviously relied on the document.
The Order 7 Rule 14 applicable in all cases.
Only when he relies on a document. Only when he relies on a document. Here, no document.
Can you consider if this statement is plaintiff has to? Because the defendant, this is also due to cast upon the defendant also. That's why this Order 14 has been newly incorporated.
Order 14, 714, yes.
Mandatory provision is there.
It is there, no doubt on that. But what will be the effect of that? Let us see. No. Unnecessary pendency of matter.
Your lordship.
No, not that. We may come back to anyone, but here, let us see the facts of this case. This is rather counterintuitive. At the 7-11 stage,
He's saying recovery of position. He should get the position is there. He should.
that he will prove in the suit. Need not
That is required.
evidence need not be pleaded. Evidence need not be pleaded. That is self. Cause of action is there. See the plaint.
Cause of action, he says, I'm deciding to complete a different plot of land. That's why I'm seeking first.
Dealing with
report of the company.
No, we cannot look into any other document.
Completely harassing.
No.
Completely harassing. The only suit is filed without any document.
We file an application for discovery.
Not the object, mother can be considered orders. That is not
No. The present challenge has been preferred against an order whereby the defendant stroke petitioner's application.
Because I cannot make it.
Yes.
Supreme Court said order 7, rule 11, and order 7 rule has to be obtained.
Yes.
Give me 1 minute. This is regarding the conduct.
Which parameter?
Para 23.5. Our concord against both running the civil civil action is however the plus under context. Limited and for the city of an article that is declared under the conduct of full to the due to the second book. With the documents.
This is different. Having regard to 7, please come to 23.8.
Having regard to the order 7, the
Documents fined under 714 along with the plaint can be looked into for the purpose of rejection. Definitely. Whatever document is relied on in the plaint or filed with the plaint is to be treated as a part of the plaint for the purpose of 711. You are on the reverse. Here, no.
has not filed any document. The plaint.
This is a proposition. This is not on that proposition. This says for the purpose of considering 711 documents under section. Just because the sections are common, it does not mean that there is a proposition on that, whatever you are arguing. Here it says that having regard to order 7 rule 14 documents filed along with the plaint are required to be taken into consideration for deciding application under 711. So while taking up an application under 711, court is required to look into not only the plaint but documents annexed with it. Yes, for that purpose. Here, your allegation is there is no document at all annexed.
They have not stated anything that these documents I am relying upon in the plaint.
For that, the plaint cannot be rejected. I'm.
These two judgments.
Yes, very.
2012 also said.
The present challenge has been preferred against an order whereby the application of the defendant stroke petitioners under Order 7 Rule 11 of the Code of Civil Procedure, for rejection of the plaint in a suit filed by the plaintiff stroke opposite party was rejected. Next para. The suit was filed inter alia for confirmation of title, interest and possession of the plaintiff over the suit property, for declaration that the plaintiff is the sole and absolute owners of the scheduled property, as well as for permanent injunction and ancillary reliefs. Next para. Learned counsel for the appellant argues that no document whatsoever was mentioned in the plaint, nor filed along with the plaint within the contemplation of Order 7 Rule 14 of the Code of Civil Procedure, thereby rendering the plaint bad for non-disclosure of cause of action. Next para. Learned counsel submits that the provision under Order 7 Rule 14 of the Code of Civil Procedure is to be taken into account while deciding an application under Order 7 Rule 11 of the Code of Civil Procedure. Next para. Learned counsel further submits that during pendency of the suit, an application was filed under Order 26 Rule 9 of the Code of Civil Procedure, in connection with which an order was passed allowing the same, and a report was filed by the commissioner, which, however, was subsequently set aside. Be that as it may, learned counsel submits that the said report ought to be looked into in order to show that the plaintiff does not have possession in respect of the suit property. Next para. Learned counsel cites such and such reported at 2012 8 SCC 706, as well as such and such reported at 2020 volume 7 SCC 366 in support of his propositions. Next para. Upon hearing learned counsel, however, it transpires that the learned trial judge was justified in passing the impugned order. Before proceeding into the adjudication, the provisions of Order 7 Rule 14 as well as Order 7 Rule 11 of the Code are required to be reproduced below. Order 7, 11 or 14. Next para. As per Rule 14 of Order 7, where a plaintiff sues upon a document or relies upon document in his possession or power in support of his claim, he shall enter such documents in a list and shall produce it in court when the plaint is presented by him, and shall at the same time deliver the document and a copy thereof to be filed with the plaint. Next para. Furthermore, where any such document is not in possession or power of the plaintiff, he shall, wherever possible, state in whose possession or power it is. Next para. Thus, it is evident that for Rule 14 of Order 7 to be attracted, the plaintiff has to sue upon a document or rely on a document in his possession in the first place. Next para. On a meaningful and composite reading of the plaint in the present case, the court does not find that the plaintiff has relied on any document or even referred to any document as such throughout the within the four corners of the plaint. The plaintiff has sought confirmation of his title and possession in respect of the suit property on the premise of the averments made in the plaint. Next para. Undoubtedly, if the defendants have a grievance regarding no document in support of the plaint case having been produced, the defendants always have the remedy to seek interrogatories and or discovery. Full stop. Next para, even otherwise, comma, it is the plaintiff who has to stand or fall on his own case by establishing the plaint case by way of cogent evidence. Full stop. However, comma, such questions can only be gone into at the stage of trial. Full stop. Next para, in Church of Christ Charitable Trust, Supra, comma, cited by learned counsel for the petitioner, comma, the Honorable Supreme Court was adjudicating a matter in connection with a suit for specific performance. Full stop. In such context, comma, it was observed that the plaintiff, comma, to get a decree for specific performance, comma, has to prove that there is a subsisting agreement in his favor, and the second defendant has the necessary authority under the power of attorney. Full stop. The Honorable Supreme Court further proceeded to hold that in the light of the controversy therein, comma, upon going through the averments in the plaint, comma, the Honorable Supreme Court found that in paragraph 4 of the plaint, it was alleged that the second defendant as agreement holder of the first defendant and also as the registered power of attorney holder of the first defendant executed the agreement of sale. Full stop. Next para. The Honorable Supreme Court also observed that neither of the documents were filed along with the plaint. Full stop. Next para. In such context, comma, the Honorable Supreme Court took into consideration the provisions of Order 7, Rule 14, and held that the said provision mandates the plaintiff to produce documents on which the cause of action was based, and went on to further observe that in the absence of such documents, comma, there was no disclosure of cause of action in the plaint. Full stop. Next para, as opposed thereto, comma, the provisions of Order 7, Rule 14 is not attracted at all in the present case, comma, since from a perusal of the plaint, comma, as indicated above, comma, the court does not find any document to have been specifically relied on or mentioned in the plaint. Full stop. Next para, in Dahiben Supra, comma, the Honorable Supreme Court held that having regard to Order 7, Rule 14 of the Code of Civil Procedure, comma, the documents filed along with the plaint are required to be taken into consideration for deciding the application under Order 7, Rule 11 within bracket small a of the Code. Full stop. When a document referred to in the plaint forms the basis of the plaint, comma, it was held that it should be treated as a part of the plaint. Full stop. Next para. Thus, comma, the entire gamut of the said decision revolves around the scope of adjudication in an application under Order 7, Rule 11, comma, in which context the Honorable Supreme Court observed that while deciding such an application, comma, the court is not confined merely to the pleadings in the plaint, but can also look into the documents relied on or filed along with the plaint. Full stop. Next para, the said proposition, comma, thus, comma, is not germane in the present case, comma, since no documents were filed at all along with the plaint. Full stop. Next para, in view of the above, comma, this court is of the opinion that the learned trial judge was justified in rejecting the application under Order 7, Rule 11 of the Code of Civil Procedure filed by the defendants stroke petitioners. Full stop. Next para. Hence, CO 71 of 2026 is dismissed on contest, is rejected, comma, thereby affirming Order number 18 dated April 30, 2026, passed by the learned civil judge, Senior Division, Jalpaiguri Sodor Court, in title suit number 374 of 2024. Full stop. Next para. However, comma, it is categorically made clear that none of the above observations shall be construed to be conclusive findings on the contentions raised by the petitioner, and it will be open to the petitioner to take all objections taken herein at subsequent stages of the suit. Full stop. No orders to cost. Urgent settlement.
Now the amendment is now not following confirmation of that has worked. Now we just.
No, the other question, all questions are kept only. Take your points.
It has gone down that yes, party suit for confirmation.
Acha, confirmation of title is not there. Only declaration. Acha, very well. Ekbarish. Suit is for যেখানে বলেছি confirmation of title. একটা জায়গায় দেখো confirmation of title.
Suit number 62 of.
Now confirmation of title is not there. Only declaration.
Recovery of possession.
Recovery of possession.
140.
First up, যেখানে confirmation of possession বলেছি, subsequently it was converted to a suit for recovery of possession.
Suit number is number 62.
Suit number I dictated from the impugned order, certified copy of the impugned order itself.
It is finding.
আচ্ছা, দেখি একবার। Oh, thank you. Title suit numberটা হবে 62 of 2024. আর ওটা আমি একবার দেখে নিচ্ছি, আপনি যেটা বললেন 141.
Page 141.
Right. একটা লাইন অ্যাড করে দিই, কনফার্মেশন অফ পজিশন যেখানে বোল্ডে করে দিলাম করে নেবো। সাবসিকুয়েন্টলি the prayer regarding confirmation of possession has been converted to a decree for recovery of possession. Declaration of title still remains. Yes. Next. আছে পাসওয়ার্ড কি ডাকো পাসওয়ার্ড করেছিলাম না নট রেডি করি
No, password.
ও মিস্টার দাসগুপ্ত ইয়েস
Number 3 password.
শিবশঙ্কর ব্যানার্জি এসছে
He's being shown in the screen. I can see his name.
Yes, Mr. Banerjee, please unmute and
Yes, I'm there,
yes.
I'm there.
Yes, what is
My lord,
Mr.
usually
Banerjee is a-
227 is
yes, that is my first question. Right.
227 is not maintainable lordship, but in a only exceptional case where there will be a miscarriage of justice, the court can interfere. There are two judgments which my learned colleague, junior colleague will hand over to your lordship. Lordship, only thing which I want to say in this matter, that the suit was for a partnership issues. Then there was animosity developed between the parties. Based on that, 16 suit was filed against each party. So I made a counter claim.
Arbitration Act. Arbitration
For
and conciliation.
resolution. But I made the counter claim after framing of the issue. Now the Ashok Kalda judgment, which my learned friend will show, that clearly goes against me. That after framing of issue, it cannot. But in the
Mr. Banerjee, first let me satisfied on the 227 aspect of the matter. I have serious
Yes, my lord.
reservation on that. First satisfy me that 227 is maintainable, then I'll go into the merits.
My lord, so far as maintainability is concerned, there are two judgments. If your lordship kindly takes up.
Cite those.
Yes.
Yes. One has been
Serosoft
handed over to
one.
me.
Yes, lordship. And the other one.
You have got only one
Kelvin.
judgment.
Yes, lordship.
Only
two
one
judgments.
judgment has
One
been
is
handed
of
over
Delhi
Ashok
High Court,
Kumar
one is of
Kalra.
Supreme
No other judgment. Only Ashok Kumar Kalra has been handed over to me, nothing else.
Kalra is on the point of
So what are
can
the judgments
file
on
my-
227? 227
lord.
judgments.
These two judgment is maintainability of 227.
Cite those judgments.
Lordship, one is the 2024 SCC online, Delhi 7137. Kelvin Air Conditioning and Ventilation System Private Limited. Lordship, may I hand over that judgment to your lordship? I
Yes,
will
yes.
request my, yes. Lordship, kindly see paragraph 10. The mother judgment was IDFC First Bank. Now, Lordship, kindly 10. There it has been decided where the coordinate bench of this court has enumerated certain circumstances wherein such type of petition can be entertained. If we read paragraph 9, then paragraph 9 was talking about 227.
although in that case, the challenge was that in the context of the dismissal of the application filed under section 16 of the arbitration and conciliation, but the observation are equally important in the present context. The relevant portion of the aforesaid judgment read as follows. Where there is no doubt a remedy under 226 and 227 are available against the order passed by the tribunal, such challenge are not to be entertained in case where every case and the court has to extremely circumspect. Recently in such and such judgment, after considering all the decision, the Supreme Court in deep industry and such has laid down circumstances in which such petition ought to be entertained. The relevant portion of the judgment read as follows. Then Lordship kindly see next page. Perusal of the above decision shows that the following principles are settled in respect of the scope of interference of 226 to 27 in challenging to an order of arbitration under section such and such. The arbitral tribunal against which the petition under 227 would be maintainable. Non-obstruction clause of 25 does not apply in respect of exercise of the power under 227, which is a constitutional provision for interference. For there is no exceptional circumstances, although interference is permissible unless and until the order is so perverse that it is patently lacking in inheritance jurisdiction of the Red Court or good interference. The interference is permissible only in order to completely perverse that the perversity must stare at the face. The High Court ought to discourage litigation which is necessary. Excessive judicial interference in the arbitration is not encouraged. It is prudent not to exercise the duties under such and such. The power should be exercised in exceptional rarity or in there the bad faith in which shows efficiency in the arbitration person ought not to allow. Lordship, these are the factors this judgment deals. This is the position where it talks about that where this can be done. Lordship, am I audible? Lordship?
Yes.
Lordship, in that case, these are the cases. So 227 is not a major hurdle for me.
What is the other judgment? You said two judgments are there. Another
Lordship,
judgment?
these are all followed. These are all followed. Serosoft is the other judgment, Lordship. May I hand over that judgment as well? But this one judgment which sum up all the judgment of the High Court and the Supreme Court.
Very well.
Yes, Lordship.
No,
So,
but
Lordship,
Mr. Banerjee, what is the patent perversity here also?
yes,
Otherwise,
Lordship. Lordship, that I will come to your Lordship. What is the patent illegality?
yes.
Whether, and then even if it is a patent illegality, my second impediment will be even that patent illegality is supported by a Supreme Court judgment, which is Ashok Karla, which is in favor of my learned friend. Now, Lordship, kindly quickly.
Mr. Banerjee, this requires hearing. So if this requires hearing in the sense that it's at best it can be a legal error, or this is not a jurisdictional error even, and let alone it being so perverse, it's evident on the face of it. If it requires hearing, then Mr. Banerjee, 227, we generally do not interfere. That's the norm. Otherwise, the entire purpose of the Arbitration and Conciliation Act will be
this
frustrated.
hearing is only required to appreciate whether the law has been rightly settled. Because why? Because
That
Lordship,
requires an
this is
hearing,
not
that
a
requires an
case.
adjudication on the law. Mr. Banerjee, that requires an adjudication on the law.
why
Legal
it is-
arguments are to be advanced. It's not a patent perversity. So
No, what I'm saying
arbitrator
is-
followed a judgment of the Supreme Court,
No.
took its own view and has passed an order. That there may be any legal infirmity, then section 5 of the 96 Act comes in, Mr. Banerjee. We cannot interfere under 226.
True. But Lordship, kindly take another sentence of mine. Anything which is legally incorrect and in course of the proceedings, it cannot be rectified, nor it
No.
can be rectified even in the appeal stage or 34 stage or 37 stage or SLP stage. Why?
For
Because
that
my
purpose only regular
counter
appeal is
claim
not
has-
provided. Regular appeal is not provided. That is the scheme of the statute,
That's
Mr.
what I'm
Banerjee.
saying.
Only
That is
section
the scheme
34
of the act.
conditions.
So this
cannot be corrected.
illegality, Lordship, this illegality will remain unchallenged forever.
Yes, it will. That
Because-
is the scheme of the statute, Mr. Banerjee. That is the scheme of the legislature. We
But
can't
no.
help it. Unsital is
Lordship,
not
why-
followed.
now thing is
Unsital
clear.
model contains a provision of
If-
challenge against section 16
If the
decision.
legal right remain unchallenged, and which takes
Yes, yes.
away prima facie my right, because filing of counterclaim is my basic right, which takes away my basic right by an order that itself remain perverse in the eye of law.
No, Mr.
Because-
Banerjee, sorry. No interference. No interference. No. The present challenge has been preferred under Article 227 of the Constitution of India against an order passed by a learned arbitrator. Full stop. Next para. Learned counsel appearing for the opposite parties raises a preliminary objection as to maintainability of the writ petition of the present application. Full stop. Learned counsel relies on Section 5 of the Arbitration and Conciliation Act 1996 to argue that there would not be any judicial
My lord,
intervention.
may I interject for a while?
Yes, Mr. Van. Let me
My
complete
lord,
the
if your
sentence.
lordship
In
kindly
any
look at-
order, in any order passed by an arbitral tribunal, except as provided for in the statute itself. Full stop. Yes, Mr. Banerjee.
I was saying, if your lordship kindly looks into, the impugned order, where my counterclaim said for certain reasons cannot be taken on record, it cannot be filed.
Ashok Kumar
If your
Kalra was
lordship
relied on. I'm
kindly
saying that.
say that does not debar me to avail other opportunity of law which are available to me, that will
No,
also
no. Why should
safeguard
I?
the interest of
Why
my
should
client.
I observe something ridiculous, such
This is not
ridiculous
part of
things?
the litigation
They
at all.
will not. Why should you?
As your lordship
If it
thinks.
prevents you in
Otherwise,
law,
lordship,
it
my
prevents you. No, that will be a meaningless
Lordship.
observation. Next
Lordship.
para. Learned counsel appearing for the petitioner cites coordinated bench judgment of the Delhi High Court in the matter of such and such reported at 2024 SCC Online Dell 7137 in support of the proposition that there is no absolute bar to maintainability of an application under Article 226 or 227 of the Constitution of India, and that such remedy of judicial review is not debarred by Section 5 of the 1996 Act. For next para, learned counsel further submits that in the event the impugned order is permitted to subsist, the valuable right of the petitioner to file his counterclaim will be taken away, causing irreparable injury to the petitioner. For next para, learned counsel further submits that although the learned arbitrator placed reliance on certain judgments of the Honorable Supreme Court, the said reliance was misplaced in law, which can be demonstrated from a bare perusal of the impugned order. For next para, upon hearing learned counsel for the parties, however, this court is of the opinion that the present application under Article 227 of the Constitution of India is not maintainable against an order passed by an arbitral tribunal within the trappings of the Arbitration and Conciliation Act 1996. To next para, the entire scheme of the Arbitration and Conciliation Act indicates least judicial interference. Section 5 of the said Act provides that notwithstanding anything contained in any other law for the time being in force, in matters governed by this part, P capital, no judicial authority shall intervene except where so provided in this part. For next para, it is relevant to mention that by double inverted this part, P capital, double inverted close, the section refers to part 1 dealing with arbitration. For next para, it will be relevant to note here that the arbitration and that the 1996 Act was promulgated in consonance with the UNCITRAL block purota UNCITRAL capsid hobe protecta model law on international commercial arbitration of 1985, which was adopted by the Indian legislature. However, the legislature of India deliberately sheared off SHEARED, sheared off OFF certain provisions from the UNCITRAL model law while partially adopting the same. For example, in the model law, there is a provision for challenge even during pendency of the arbitral proceedings if there is an adjudication on jurisdiction of the arbitrator, comma, which has been deliberately omitted by the Indian law. Full stop. Next para, also, comma, in the objects and purpose of the 1996 Act and its subsequent amendments, comma, it would be evident that the purpose of the enactment is to facilitate uh, expeditious hearing of the arbitral process and to encourage alternative dispute resolution, as well as to uh, bring up India as a hub of international arbitration. Full stop. Next para, section 5, comma, thus, comma, contains the spirit of the statute in providing alternative dispute resolution, comma, omitting unnecessary judicial interference as far as possible. Full stop. Next para, seen in such perspective, comma, although it is correct that a constitutional remedy of review under Articles 226 and 227 cannot be completely cut off by a servient statute, comma, which operates under the Constitution, comma, including the 1996 Act, comma, still, comma, additional rigors should be imposed by the court on itself while taking up an application under Article 226 or 227 in respect of a matter specifically barred under Section 5 of the 1996 Act. Full stop. Seen in such context, comma, even in Kelvin air conditioning Supra, comma, the learned single judge of the Delhi High Court took into account certain safeguards, comma, which are also flagged while holding that interference under Articles 226 to 227 is not barred. So, for example, comma, the learned single judge held that such interference shall only be in exceptional circumstances and unless and until the order is so perverse that it is patently lacking in inherent jurisdiction, comma, the writ court would not interfere. It was further observed that interference is permissible only if the order is completely perverse, that is, the perversity must stare in the face. Full stop. It was also observed that high courts ought to discourage litigation which necessarily interfere with the arbitral process and that excessive judicial interference in the arbitral process is not encouraged and it is not prudent to exercise jurisdiction under Articles 226 stroke 227 and such moreover, full stop, moreover, comma, such power should be exercised in single inverted exceptional rarity, RARITY, inverted clause, or if there is our quote unquote bad faith which is shown. Full stop. The learned single judge went on to observe that efficiency of the arbitral process ought not to be allowed to diminish and hence interdicting the arbitral process should be completely avoided. Full stop. Upon summing up, comma, it was observed by the learned single judge of the Delhi High Court that only under exceptional circumstances or when there is bad faith or perversity that writ petitions ought to be entertained. Full stop. Next para. The question raised in the writ petition is whether the interpretation of certain judgments of the Honorable Supreme Court, comma, particularly in Ashok Kumar Kalra versus Wing Commander Surendra Agnihotri and others, comma, reported at 2022 SCC 394 is concerned. Full stop. Thus, comma, any interference under Article 227 in the present case would take us to the domain of judicial interpretation and detailed arguments regarding the law governing the subject and which cannot be termed as a patent perversity or bad faith or perversity so evident that it stares in the face. Full stop. Next para. The question raised by the writ petitioner is one of judicial and legal interpretation, comma, which requires legal arguments to be advanced in extenso and is not and does not involve any perversity apparent on the face of the impugned order. Full stop. Next para. Hence, comma, even going by the principle laid down in Kelvin air conditioning Supra, comma, no interference is warranted under Article 227 of the Constitution of India. Full stop, next para. Accordingly, CO 59 of 2026 is dismissed as not maintainable without any order as to costs. Full stop. Needless to say, comma, this court has not entered into the merits of the respective contentions of the parties otherwise. Arjun certificate.
Deeply obliged.
Thank you and sorry, Mr.
Obliged,
Ganesh.
obliged.
Yes, next.
Item number 5.
None appears for the parties. You are appearing? Oh, sorry. Yes.
This petition under section 24 of the
You
transferring
matrimonial. You're the wife.
and wife.
What are the grounds?
That she is financially unable, she is physically unable. Apart from that, she's only offspring of her parents. Parents and also seriously.
What there is any child of the marriage? You were wanting transfer from where to where? Distance? Howrah to Jalpaiguri. Very well. In view of a prima facie case for transfer having been made out, comma, the matter is required to be heard on merits. Full stop. Accordingly, the appellant, the petitioner shall serve a copy of CO 73 of 2026 on the opposite party, indicating that the matter shall be listed for hearing before the appropriate bench of the next circuit. Full stop. The petitioner shall file an affidavit of service on the at the time of hearing. Full stop. There shall be stay of all further proceedings in matrimonial suit number 488 of 2026 pending before the learned additional district judge, 4th court at Howrah, till disposal of the revisional application of this application.
The petitioner and the divorce petitioner. Is residing at US. Residential. Dilwa. Some Dilwa as well as US.
You have given both the addresses here? Yes, yes.
We find that the back page of the divorce petition, we have filed that name of the advocate is also there. The advocate of the husband petition.
So we'll direct you to serve on.
Yes.
Very well. যেখানে বললাম shall serve a copy of the on the opposite party and stroke or the learned advocate appearing for the opposite party in the trial court. Bankita যা আছে. Thank you. Good to see you after a long time. You appeared very little in my court actually. I had very little privilege of getting your arguments.
Almost every day, but
No, but unfortunately not in my court maybe. Good. Next.
Number 6.
Yes, Mr. Rahman, what is your case?
7 rule 11 has been rejected.
Rejected?
Yes.
You have to make out a very strong case, 711. No, what is the suit for?
A suit for declaration, recovery of possession, another consequential list. When it takes up the prayers made in the plaint, the plaint starts at page number 26.
Prayer set at page 34.
Yes.
Yes.
Page 34 is the prayer portion.
Right. So on what ground did you seek for
But
rejection?
the declaration of title has been sought for along with recovery of possession, trust possession. Section 7(5) would be applicable with Court Fees Act. Ad valorem court fees have to be paid.
But Court Fees Act plaint cannot be rejected. The chance has to be given to him.
Yes, but my petition was outrightly rejected without even asking them to pay the proper court fees. A suit has been valued at just rupees 200 and only 20 rupees court fee has been paid as per the statements made in the plaint. And
the present revision has been preferred against an order whereby the defendant stroke petitioners, one defendant or
here only one petitioner has filed.
Defendant stroke petitioner apostrophe S application for rejection. কি বললাম?
Here the defendant number 1 has come up before this.
Yes. Has been preferred against an order whereby the application of the defendant number 1 stroke petitioner under order 7 rule 11 of the Code of Civil Procedure was rejected by the learned trial judge. Next para, learned counsel for the petitioner contends that the suit, comma, as framed, comma, is patently undervalued, comma, in view of the declaration of title being sought along with uh, possession, khas possession, recovery of possession. So next para, it is submitted that under Order 7, Rule 11, within bracket,
Clause B, my lord.
yes, B, small b, comma, where the relief claimed is undervalued and the plaintiff, on being required by the court to correct the valuation within a time to be fixed by the court, fails to do so, comma, the plaint will be rejected. Push up. However, comma, in the present case, comma, the learned trial judge, comma, it is submitted, comma, rejected the application under Order 7, Rule 11 outright without entering into any inquiry as to whether the suit was undervalued and stroke or directing the plaintiff to correct the valuation. Who's the next para? This revisional application is required to be heard on such question. Accordingly, the petitioner shall serve copies of the only one plaintiff.
Plaintiff is only one plaintiff, but by rest of the pro forma defendant.
Very well. Copy of the revisional application on the plaintiffs to opposite party number 1, indicating that the application shall next be listed in the next circuit for final.
Kindly keeps it on Tuesday, my lord. In the meantime,
don't take a risk.
Well,
Just because I've admitted because the other side is not there. I've not even looked into the order.
No, well, kindly keeps it on Tuesday.
Sure. But there are other things I have not looked into.
Yes,
something caught my eye, but
my lord keeps it on.
Delisted on June 16, 2026, when an affidavit of service to that effect shall be filed by the petitioner. There shall be stay of all further proceedings in title suit number 534 of 2024, pending before the court, first court of learned civil judge, junior division at Jalpaiguri, till June 19, 2026, or until further order, whichever is out there. If you can't serve, then we'll extend.
Lord, yes.
Number 7.
Mominur Rahman. Yes. But still write it, yes. This is the second occasion when none appears to move the revisional application. As a last chance to the petitioner to move the matter, the same is adjourned for the day. এগুলো কাল দেখিয়ে দিই last chance.
Number 8.
Last chance ছিল. It was recorded in the order dated June 10, 2026 that a last chance was given to the petitioner to move the matter. To sub next para, the previous orders dated April 10, 2026 as well as April 20, 2026 indicate that the matter was adjourned on the prayer of the petitioner. Even today, at the time of call, none appears to move the revisional application. Accordingly, CO number 17 of 2025 is dismissed for default. Interim order, if any, stands vacated. No order is to cost.
Number 9.
Lordship, I'm for the petitioner, my lord. The difficulty is, my lord, I am unable to contact my client, but because my lord, this is an application against the order under section 24 of the Hindu Marriage Act. There's a direction before by the earlier honorable court to take instruction how much money he has already been paid to the wife and his salary slip. But my lord, I have not been able to get it.
After that, you could not contact him.
No, lordship, that is why my
When the salary slip was called for, the husband went missing.
husband, my lord.
Very good. I am
what
dismissing for
happened, my
default.
Yes, your lordship. Kindly.
Learned counsel for the petitioner submits that she has not been able to contact her client despite best efforts. It transpires accordingly. Now, it is further pointed out fairly that on a previous occasion, the learned advocate for the petitioner was directed to ascertain as to the current income and salary slip of the petitioner. Next para, in the circumstances, it seems evident that the petitioner is no longer interested to proceed with the matter. Accordingly, CO 153 of 2025 is dismissed for default without any orders to dismiss for non-prosecution without any
Kindly make it dismissed for default, Lordship.
this is for default without any orders to cost. Interim order, if any, stands vacated. Thank you.
Grateful, Your Lordship.
Thanks.
Item number 10.
Appearing, Mr. Datta?
Yes.
Yes. You are for the other side? Yes. Yes.
My Lord,
Lord.
this is the revision against the rejection of the amendment application. But
Amendment of plain or written statement?
amendment of written statement. But due to mistake, the original written statement that was sought to be amended was not annexed. As such, I required to file one.
Yes, give a copy to them. You have a copy of the original written statement?
No.
Written statement you should have. The client should have given.
Actually, I have not been supplied with that.
We will take a copy, come back tomorrow then. I'm taking that on record, Mr. Datta. Come back tomorrow because let him go through it. On the prayer of learned counsel for the petitioner, leave is granted to the petitioner to file a supplementary affidavit in order to incorporate on the record, in the records, the original written statement, comma, the amendment of which was refused by the impugned order. For sub next para, the said supplementary affidavit, comma, filed in court today, comma, be kept on record. Stop. A copy thereof is handed over to the learned advocate for the opposite parties here and now. Stop. To enable learned counsel for the opposite parties to prepare himself in the matter. The same is adjourned for the day. Please come back.
Item number 11.
Item number 11, Lordship, I am for the petitioner, Lordship. But the contacting advocate, Lordship.
Pardon?
But the contacting advocate today, she is not present, Lordship. Kindly 1 day accommodation, Lordship. I am praying for 1 day accommodation.
This is the second day you are paying for accommodation.
Your Lordship.
Somebody else paid for accommodation.
Lordship,
Mr.
kindly.
Subhrajyoti Lahiri.
Yes, Your Lordship.
He is seeking for accommodation on your ground and you are seeking accommodation on his ground.
No, Lordship, no, Lordship.
On the prayer of the petitioner, the matter is adjourned for the day. Full stop. However, comma, it is, since this is the second occasion when such prayer is being granted, a last chance is being given to the petitioner to move the matter. Full stop. The same may be listed tomorrow under the same heading. Last chance I have recorded. There will be no option for me but to dismiss for default if you don't appear. Yes. You come prepared if he is not there, and vice versa. He'll give your appearance. Yes. Yes, next.
Item number 12.
Lordship, item not
Yes.
for the petitioner. Lordship, in the last occasion, my Lord has directed me to produce the examination, cross-examination of the DW1.
Just remind me in a nutshell. I'll just
Yes,
check up
this
my
is
previous one.
the case of the amendment sought for during the course of trial. And whether my diligence has been acquired, whether the knowledge has been come to at that time of cross-examination, that has been a moot question at the time of hearing. My learned
Right.
friend raised the objection that because of the impugned order, page 63, shows that it is my contention that I come to learn. But Lordship, I have filed a supplementary evidence without the learned honorable court's permission.
You had relied on page 63.
Yes,
In
Lordship.
page 63, in an order, it was recorded that
The
you sought adjournment on the ground that it was revealed. So you have now brought that evidence.
Evidence. Lordship, on one point, Lordship, my Lord had directed me to the only examination and cross-examination. Furthermore, I have filed something that has been ordered and petition, and I have filed on the date. Kindly, those are all.
You have got copies of this?
Just I have received. I have
Just-
It's the same as previous.
No, Lordship, I filed this 12.
No, just one
Well,
hour.
you must have been busy in other matters.
Working time he has supplied me.
No. I will take it up tomorrow, Mr. Ramashi.
I have no.
On the prayer of the petitioner, no, you have directed. I had directed you. No.
Yes.
Yes. There's a direction.
Supplemented affidavit was direct.
No. That is
Very
it. That is I have
Supplementary
no-
Very well. The supplementary affidavit filed today be kept on record. Full stop next para. A copy thereof is served on the learned advocate for the opposite party here and now. To enable the opposite party to argue the matter, contest the matter effectively, the same is adjourned for the day.
Develop.
Thank you.
Item number 13.
আগেও নষ্ট হয়েছে নাকি ছেড়ে দাও নন এমএসসি ম্যাটার ফালতু সাফার করো জাস্ট নট টু করে ছেড়ে দাও আচ্ছা একটা অর্ডার রেকর্ড করো না কারণ প্রত্যেকদিন না হলে none appears for the parties at the time of call let them attend adjourn for the day এটা একটা তন্ময় টেমপ্লেট করে নাও মনে হচ্ছে বেশিরভাগই তাই হবে
Item number 14.
who will ask for time choose
We have served copy but not delivered.
not delivered means with what endorsement
Lordship, we have served copy upon the respondent but not delivered through post.
till date not delivered or
Yes.
it came back
Till date not delivered, Lordship. So 17, within 17, I believe.
very well on the prayer of the petitioner comma the matter is adjourned till June 17 2026
Lordship. Lordship, in regard to item number 18, same.
let it be called first
Lordship.
call করে যাও
Item number 15, 16.
now you're appearing
Lordship.
yes
Mr. Hirok Barman is there. Actually, there are two appeals, Lordship.
Mr. Hirok Morgan is there
Actually, is there actually. Call করতে Hirok Barman.
I'm passing over
15 and 16. Both
15 and 16 I'm passing over call Mr. Hirok ask someone to call
Lordship.
next ডাকো 15 16 है
Item number 17.
Lordship, I am on behalf of the appellant, Lordship. Actually, matter is ready for hearing, my lord.
well on the prayer of the respondent the matter is adjourned for the day adjourned till June 15 2026 come back on
Grateful, my lord.
but the other matter I have passed over if Mr. Borman comes I'll take
Lordship.
Item number 18.
18 you are saying something yes
Lordship, kindly take up the matter on 17, as because we have served, not delivered.
very well on the prayer of the petitioner the matter is adjourned till June 17 2026
Grateful.
thank you
Item number 19.
Lordship, item number 90, I am for the petitioner, Lordship,
petitioner
Lordship, claimant,
acha
petitioner.
you are the petitioner before us before this court
Yes, Lordship.
so what is your prayer
Lordship, kindly fix it Monday, Lordship, senior has gone to Kolkata for some.
who has gone to
Senior, Lordship,
who is your senior
Supriya Singh, Lordship.
on the prayer of the petitioner the matter is adjourned till June 15 2026
Item number 20.
Lordship, Hirok Barman has come, man.
20 who is appearing first let
20 I am appearing, my lord.
20 also you are appearing
I'm
the other
appearing.
side is not there
Other side is not happening.
well, none appears for the opposite party although the petitioner is represented through counsel let the matter stand adjourned for the day এবার পাস ওভারটা ডাকো 15 16 15 16 একসঙ্গে we'll take up
Pass over matter item number 15, 16.
Lordship, there are two, actually, for the same judgment, two orders, two appeal has been filed, my lord.
why
Actually, one from the side of the
company and
petitioner,
one by
one,
the claimant.
one, from Lordship.
both of you are dissatisfied I'm allowing both appeals demanding it it will be easiest option for the court
So, so far I understand, Lordship, from the.
so some amount was given you are
I-
agreed to by
No,
that
no, no. Actually, nothing has been satisfied, Lordship. Actually, they are coming, actually, they're challenging the order passed by the learned tribunal, Lordship.
No, you are appealing for the claimant
I'm appealing for the claimant for the interest purpose. Because interest has not been granted. And from their view, they are actually challenging the order.
so let us hear them first because Mr.
No, but before hearing, Lordship, our appeal has not yet been admitted.
I'm admitting and hearing right now what is the difficulty
We have to file the paperwork also.
Paperbook is ready, my paperbook is ready, Lordship.
same order
Same.
your memo will have to be incorporated
Lordship.
Yes, I will file, let me,
your appeal has been filed the appearing also today
yes, not admitted.
oh, which one is your appeal
Item number 16.
item 16 একটা রেকর্ড করতে হবে since arguable questions of fact and law are involved and the self-same impugned judgment has also been challenged by the claimant on a limited aspect comma FMAT within bracket MV 102 of 2024 is admitted comma to be heard on the grounds taken in the memorandum of appeal and is directed to be heard along with FMA 49 of 2024 full stop the paper books filed in connection with FMA 49 of 2024
Let the paper book be taken on the record, my lord. TCR is also required to, the paper books there. all the
shall be
documents-
treated to be treated to be paper books for the purpose of the present appeal as well. Push up next para. A copy of the memorandum of the present appeal shall be served on the learned advocate for the claimant stroke respondent by the learned advocate for the appellant during the course of the day. Please hand over a copy of your memo today itself.
Lordship, may I
The
submit the
paper books, the paper books in connection with FMA 49 of 2024, filed today, be kept on record. You have given a copy of the paper book to him. A copy thereof is served here and now on the learned advocate for the insurance company. Push up. Then he'll have to go through that paper book.
Lordship,
I'll keep it
tomorrow,
on.
Lordship, Lordship.
Huh? This
The
no,
same-
this will be
same,
treated
all
as
the
your
documents
paper
are
book.
same, all the documents are
I've
same.
said this paper book will be treated as your paper book. It contains all the.
Absolutely, Lordship.
That is what I have said. This will be treated as a paper book
Everything
in
is-
your matter also, and your memo, you give a copy to him.
Lordship.
We'll take them. That memorandum will be the additional document only. The rest is same.
Lordship.
So we'll take up on their paper book and take your grounds of the memo.
Kindly keep it tomorrow, Lordship. No.
Tomorrow he won't be able to prepare himself.
Monday, Lordship.
Your paper book has only.
I've
Monday,
already
Monday.
had- Lordship.
That appeals will be taken up together for hearing under the same heading on 15, June 15.
Grateful, Lordship.
Thanks.
লক্সনে কি তুই আছিস না লক্সনে পরেরটা দেখছিস
না, sorry.
হ্যাঁ
In the appearance slips, please give, please write you are for appearing for the appellant in this matter and give the FMA numbers.
She will
And
write it.
vice versa for you.
She will write it, Lordship.
Write his name also. Give one slip, writing his name also. Appellant such and such, respondent such. and
Lordship,
such.
Lordship.
Mr. Borman will save paper
Lordship.
and trees.
Sure, sure, Lordship.
Next.
Item number 21.
Lordship, for in item number 21, I'm not praying. I'm praying not today, Lordship. I'm praying.
I'm
for-
just granting not to, not recording
Not
anymore.
today,
Please.
Item number 22, 23.
Lordship, this is just a performance, just a performance was there.
He escaped.
The Lordship,
He
senior is
escaped
not,
right now.
Just he
senior
was
is
sitting
not
there.
ready.
Yes, he was sitting. What not ready? Call him. He's outside.
He's
not
outside.
ready.
He didn't bring the brief also, Lordship.
Not today.
Not today.
Lordship, keep it on Monday, Lordship. Two cases.
He'll not bring the brief tomorrow also.
Lordship,
He'll bring the brief tomorrow. Today he has not brought his brief. I'm granting not today. Tomorrow, what is the
He's
decision?
escaping. Every time he's escaping. That is the problem. In the last circuit.
Unless he has a better matter. No, not today only.
Actually, award,
Remind me tomorrow. That he's escaping.
award has not been satisfied, my lord.
Come back tomorrow. We'll hear
Lordship,
him.
Lordship.
You are also appearing in this matter.
No.
Next matter.
Next matter.
Item number 24.
24. I am for the appeal. Insurance company, Lordship.
Appellant, insurance company is
Insurance.
appellant. Who is the respondent? The claimant is-
Respondent. Hey. okay.
Now he is escaping.
No, I'm not. Which one? There is a
Next one, you are the respondent. Boomerang.
Lordship.
Yes.
Which one? Nila.
Number
Number হচ্ছে
Neela Rai Sarkar.
24.
24.
Lordship, actually, in this matter, I'm appearing on behalf of the, actually, I just missed, I apologize, Lordship.
It comes back to you.
Lordship, I just received the actually instruction from my junior brother from Siliguri.
Achha.
So I need some time, my lord.
Lordship, actually, TCR is called for paper book is to be submitted.
No, those have not been directed.
No.
So I'm directing that.
Lordship.
Well, you are not making any interim prayer.
No.
Very
No, not needed that. It's all
Good.
finally hearing.
Good. The appeal is admitted and shall be heard on the grounds taken in the memorandum of appeal. Push up next para. In view of the appearance of the respondent, please file your, have you filed your vakalatnama?
Yes. File করছিস last day
Yes, I
year
filed,
also
filed,
filed.
Uh,
Noted.
In view of the appearance of the you are for the claimant respondent.
Claimant respondent.
One.
Lordship.
Only one.
Only one to four.
One.
Let me check.
Actually.
There are other respondents also. Owner is also must
Owner
be.
is also there. 6 and 7. 6
Achha,
is
very
the owner and 7 is the another insurance company. That means the
Achha,
victims.
Very understood. 1 to 5 you must be appearing. Please check up.
1 to 5.
Should I ask him? Actually, right now I'm not carrying the document, my lord. It is.
In view of the appearance of
If there are
respondent number,
petitioners, my lord, I'm appearing.
yes.
1 to 5,
In
they are
view of the
petitioners.
appearance of claimants took respondent numbers 1 to 5 through their learned advocate, service of notice of the appeal is dispensed with on the said respondent. Push of the appellant shall put in postal costs and requisite for service of notice of the appeal on the respondent number 6 and 7 within a
It is not required. I am insurance company. The point is only the income and nothing else. They are not required at this dispenses.
no insurance company. Suppose we hold that insurance company is not liable, then it
No,
shifts to the owner.
Actually, they are actually.
I am admitting that.
They are
I'm
admitting the
admitting
liability.
that Lordship.
Service of notice on the respondent number 6 and 7 is dispensed with on the prayer of learned counsel for the appellant. For the next para, the appeal may be treated to be ready as regards service. The trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a fortnight from date. The appellant shall prepare and file the requisite number of paper books within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Grateful, my lord. Thank
Didish.
Again, number 25.
you. Not true.
Again, number 26.
Say.
Again, number 27.
Not.
Again, number 28.
Same.
Again, number 29.
You are appearing?
No. 20. Or 20.
28. No, you are not appearing.
Yet to be ready.
So I've just made it not today. Yes.
29.
29 and on behalf of the appellant.
Of the
Appellant.
appellant.
It is filed within time, started deposit.
What about the respondent? So I'm directing the previous as the previous matter. Admitting the appellant. No interim order scope.
No.
তাহলে আগেরটা যা হলো তাই হবে appeal will be heard on the grounds taken in the memo of appeal owner. Sorry, আমি বলে দিচ্ছি নতুন. This appeal will in view of mixed questions of fact and in view of questions of both fact and law being involved, the appeal is admitted to be heard on the grounds taken in the memorandum of appeal. The appellant shall put in postal costs and requisites for service of notice of the appeal on the respondents within a fortnight from date. The trial court record shall be brought by special messenger at the cost of the appellant, also to be deposited within a fortnight. Appellant shall prepare and file a requisite number of paperwork within 8 weeks. Liberty to mention.
And so far, owner is we pay for dispense of service.
Owner is which respondent?
Respondent number 2.
2.
Lord. Respondent number 3. HON'BLE. Respondent number 3.
There are total 3 respondents.
Yes. 2 claimants, 1.
Very well. তাহলে ওখানে service postal cost and requisite যেটা বললাম for service of notice on the respondent numbers 1 and 2. আর ওখানে একটা লাইন অ্যাড হয়ে যাবে service of notice on the respondent number 3 is dispensed with on the prayer of the appellant.
Again, number 30.
30. I am for the insurance company. Affiliated.
Similar. Owner is which respondent? 1 to 3 will be served with postal cost 1 to 3 আর 4টা dispense with. ঠিক আছে তো? হ্যাঁ. Next.
Again, number 31.
I am for the appellant claimant.
Appellant claimant. So you have served notice, no?
Lordship, I have served, but
it has to be admitted
it
from.
has not been directed. That is, I am not saying.
No, it will be easier for you because you are the claimant. You have not got the money.
Yes.
Go. You are aggrieved with the quantum. I'll admit the appeal and direct you to serve. No interlocutory application is there. No interlocutory application is there.
No, nothing. Within time.
So then, like the previous matters, I am directing the appeal will be heard and postal cost and requisite everything is.
With direction of paper books.
Paper books also and liberty to mention. Paper books within 8 weeks from service of notice. And should I dispense with on anybody? You are the claimant. I should not dispense with. Because insurance company and owner both.
Owner may be dispensed.
Dispensed with.
Owner is not.
Insurance company has not disputed that they are liable. Suppose if I hold that insurance company is not liable, then owner will be liable.
We have not filed any appeal. I shall serve.
Compensation has been given to you. Some compensation has been given.
Some compensation has been given.
Oh,
I have come up for enhancement.
Thale ota, which is the respondent? Which respondent is the owner?
Respondent number 1.
1 is the owner.
1 is the owner.
না না আমার মামলাতে
Insurance company?
this is two
Insurance companies too?
respondent two.
No, no, serve on both the parties. Postal cost and requisite for service on the respondents. Serve both. Put in postal cost for both. এটা কোনো dispensation নেই, বাকি সব এক।
Item number 32.
Not today.
33.
Yes, Mr. Borman, you are for the appellant.
Within time.
So, like the previous matter,
We have to serve upon the owner also because.
owner also. তাহলে এটাতে ঠিক আগের ম্যাটারটা যেটা postal cost and requisite
33.
notice on the respondents. কোনো dispensation নেই, বাকি সব এক। The same, rest remains the same. হ্যাঁ, হ্যাঁ, সব থাকবে আগেরগুলো। হ্যাঁ হ্যাঁ হ্যাঁ, সব পেপার বুক 8 weeks same. Within a fortnight you will deposit the postal cost and special messenger cost. Paper books within 8 weeks from.
Item number 34 to 35.
Lordship,
Yes,
for the item number 34 claimant.
So similar.
Counter appeal is there. Together.
Counter appeal by whom?
40.
Oh, acha.
My appeal.
Insurance company is also there.
Yes. Lordship, I have a application for condemnation.
Lordship, I am for 35. Lordship, say.
Huh? Office report. And depository. Statutory deposit হয়ে গেছে তো ভালোই তো। Yes, what do you say?
Lordship, not today, Lordship.
Why not today? Yes, come in again after the previous matters were over. Yes, you have a section 5. What is the delay?
Lordship, 146 days.
Reason?
Lordship, they are actually illiterate and minors, one lady and two minor baby.
Yes, I am allowing the condonation application.
Yeah.
I am not having the brief today.
Tomorrow, Mr. Shocker, come back now. Hmm, 34, 35, হ্যাঁ। Board action, 34, 35. এটা কিছু রেকর্ড করতে। বললাম একটা অর্ডার দিলাম কি? কি দিতাম না, not today.
It is not today.
Only not today. I am not recording any order.
Item number 36.
Lord, 36 and 7, my lord. It's actually both the appeals are coming out of the same same judgment, my lord. And in both the appeals.
You are the
my
claimant and your
I am
friend is the insurance.
I am the claimant, my lord.
Lordship.
And from,
I have to
let
say
me complete,
something
let me
in this
complete,
case.
let me complete.
Lordship, in this case.
Let me complete, please.
Oh, sorry.
Yes.
So, in this appeal, my lord, though the judgment has, the award has been passed on 19/8/2023, 3 years ago, but award has not been satisfied by the insurance company. So they have also prepared one appeal before this honorable court. So on the prayer of from the side of the petitioner, both the appeals are being heard analogously and accordingly is placed. And so from our side, lordship, we have already prepared the paper book. Paper book is ready and it is required to be disposed of since they have not received a single funding from the side of the insurance company. And so my humble submission, your lordship, let the matter be taken up for hearing and be disposed of because only 2 or 3 points, my lord, future prospect interest has not been added. This is the points we have taken in the appeal, lordship. So if
Yes, what do you say?
Lordship, in this case, it's a very tough case. I'm just saying.
A tough case.
Tough case, yes, Lordship.
It will be all the more
Because
tough for
yes-
me because I am not a regular in the insurance. I'm not a regular in the insurance, this game case
It
field.
is not for you, for myself. Lordship. In this case, the insurance policy, we are challenging the insurance policy. They are not challenging the insurance policy. Insurance policy is a transit policy. That means from the
Different insurance company.
No. It is from the workshop to the showroom.
All right.
We have issued this policy, and the owner, that is the
You are arguing.
No, just, I am just saying that.
He's saying why it is tough.
Why it is
He's arguing
tough?
against
He is
himself.
explaining why it is tough.
Yes,
Why?
so arguing against himself.
Against himself.
Yes.
So let the
And
matter
Mr.
be
Balaji-
No, when so instead of hearing you first, let us hear him and dispose of the appeal then.
Lordship,
They have not.
in this case, the Balaji intervention, that is the.
That is the
our
point of
issue.
argument, Lordship. That is the point of hearing.
No, the Balaji intervention is very much necessary.
The Balaji is not appearing.
Not appearing.
You have given a notice.
In
No,
lower
actually,
court,
the
we
service
have
has been
tried
dispensed with
many
Lordship.
times,
So the
many
copy-
times. I am personally there in lower court,
Copy.
but they are not appearing. Sometimes they are saying that, yes, we have sold
So
the
let
car
the-
to anyone.
Let the argument be start.
No, Balaji has to be.
Service has been
Sir.
dispensed with since they have not contested before.
Service
No,
has
no,
been
no.
dispensed with.
Before this, your Lordship.
Then,
But in my appeal.
Because they have
Lordship,
not
it is
contested before the
dispensed.
no, Balaji not being present does not mean that the court cannot pass any order against Balaji. Balaji chooses not to
If
be
they-
present.
if the
In
liability-
my
can be done?
appeal,
If the
Lordship,
liability is fixed upon the
এক মিনিট,
Balaji, so
আমাকে
automatically
বলতে
that will be
দেখুন,
passed.
তারপরে in this case, in my appeal, my lordship, my humble submission is that give me a chance to give them a notice
Balaji,
as 1 to 4 is
Your appeal has
already
been
there.
admitted.
Yes?
Your appeal has
No,
been.
no, we are praying for that.
Appeal has been admitted.
না আমারটা appeal admit হয়নি, FMT MV তে পড়ে আছে। কি করবো এখন? আমাদের তো কিছু করার
Their appeal has not been admitted.
admitted yet.
So let it be admitted, Lordship, first.
Let it be
What is the
admitted
defect? Defect?
No defect, I think. It doesn't file within time, no?
within time.
Within time. it
Defective
has-
বলছে।
Admitted and my lordship give me a direction to serve the copy upon
Statutory
the.
deposit was not made.
Yes.
When was it made?
Within time, lordship. No defect is there, lordship.
I think
24,
statutory
11,
statutory
20,
amount.
23.
Statutory amount.
Statutory amount, 25,000, already. আমার ভুল হয়নি।
You show him the paper.
No, the report, stamp report is reported on ভুল রয়েছে কেন?
Sir, can I show?
When did you deposit?
Eight.
No, when?
23, 2023, 24, 11, 23.
Oh, the office report is updated till 18/11. I'll seek a fresh report. The office shall furnish learned counsel for the appellant in, this is in FMT within bracket MV 68 of 2023 submits that the statutory deposit has already been made. For sub next para, the office shall furnish a revised report in that regard by June 15, 2026. For sub next para, in the meantime, comma, the appellant shall serve a notice on respondent number 5 indicating that the matter shall next be listed on June 16, 2026 and file an affidavit of service to that effect on the returnable date. For sub next para, since service of notice of the appeal has already been dispensed with on the respondent number 5 in FMA 33 of 2023, which arises out of the same matter, comma, the in the event service cannot be effected on the respondent of 5 in the present appeal, comma, the court will proceed in the absence of the said respondent. Whosoever in view of the appearance of the other respondents through their learned advocate, service of notice on the respondent numbers 1 to 4 is dispensed with. Please give a notice immediately, as soon as possible, and file an affidavit of service. You are sure service was dispensed with in your appeal?
But I have to just check once, Lordship. So far,
Please check up, because otherwise I have recorded on you.
I will check it up, Lordship.
No, but today itself, tell me.
Today, my lord, today I will tell you.
অঞ্জিতা, এই আগের ম্যাটারটা একটু মার্ক করে নোট করে রেখো তো, এটাতে সার্ভিস না হলে যদি পরে মেনশন করে এটা হয়তো চেঞ্জ হতে পারে। এখন যা আছে
My lord, I may be excused, my lord.
not dispensed with.
No, I have already served upon both. As per the direction, I have served.
তাহলে
upon
since service has been done, wait, লাস্টে যে সেন্টেন্সটা বললাম না, since service has already been dispensed with, বলে পুরো সেন্টেন্সটা will be by the court will proceed, পুরো সেন্টেন্সটা কেটে দাও, ওই জায়গাটা দরকার নেই, আর কিছু বলা দরকার নেই। You serve a notice and come.
Well, let it be taken on record, service.
লাস্ট সেন্টেন্সটা কাটো, এক এক করে করো। না, কি বললাম?
বালাজি কি পেয়েছে?
হ্যাঁ, ওখান থেকে কেটে দাও, ওটা পুরোটা কাটবে, হ্যাঁ, সিন্স থেকে একদম। ওখানে হচ্ছে পুরো বাদ। তার বদল হবে affidavit of service filed by learned counsel। এটা কত নম্বর item? Your appeal is, what is the number of your appeal?
Number of my appeal is 62/2023. 62/2023.
No, what is the FMO number?
33.
33.
33/2023.
তাহলে ওই affidavit of service filed in connection with FMA 33 of ওটা be kept on.
And duly served upon both the insurance company and the owner. Yes. Next.
Item number 38.
38 actually, my lord, let it be kept on 17th. Mr. Pashupatinath is appearing in this matter, my lord.
17th করে নোট করে
17th, my lord.
নোট করে রাখো, খেয়াল থাকবে না অর্ডার পাস করছে। What happened to him?
Actually, he is sick today. The point of the appeal process.
Item number 39.
39 actually, Mr. Chakraborty is appearing, my lord. No. Chontu Manidas. Paper book is there, my lord, and TCR also arrived, my lord.
You are not appearing. Your name is there.
I'm appearing, my lord.
Who is for the other side? Acha, you are.
Chakraborty.
39 and
So then move, argue the matter if it's ready. Paper books are ready.
Lordship, I'm ready, my lord.
17th. I am not ready today. Actually,
Paper
Come,
book-
I-
my lord,
it
paper
is
book
weird,
taking-
but
my lord,
it is
just
the same
one line,
matter.
my lord.
All the
One line,
matters.
kindly record one line, my lord. I'm just submitting the paper book and also handing over the.
Without paper.
Paper books filed today be kept on record. A copy thereof is handed over to the learned advocate for the insurance company, who serve on the prayer of the insurance company with the matter stand adjourned till June 17, 2026.
The paper book is, my lord, already have filed on the last occasion. And
So what
our-
are you handing over then today?
No, I mean, 39, my lord.
So what are you handing over?
I'm taking it back, my lord. This one, my lord. Actually, I've already, it is there already. It is also mentioned. It's,
আপনি যেটা দিলেন সেটা তো
so
ঢুকে
I'm
দিচ্ছি।
taking it back, my lord. With the leave of the court, I'm taking it back.
অর্ডারটা কাটো, অর্ডারটা কেটে দাও নতুন করে।
এটা একটু নিয়ে নেবেন।
A copy of the paper book handed over today to learned counsel for the insurance company. Now, a copy of the paper book is handed over today to the learned advocate for the insurance company. Push up on the prayer of the insurance company. The matter is adjourned till June 17, 2026.
Make it 18, my lord. Because
No.
17, there are other
No further
matters, my
change.
lord.
2 changes, that's the limit.
My lord, other matters there. Already you have things.
I'll not be able to take up in any event due to you only, because you will be arguing the previous matters. So I'll not be able to take up this matter.
Lordship.
Your learned friend will be glad if you don't do the matter on the next day.
No.
He's also finding it difficult.
Not every time.
This is the result of forming a coterie in MSCC matters. Only few people are appearing, so now you have to suffer also.
No,
If the court
actually,
takes up all the matters, you have to come ready in all the matters.
Actually, he's very much cooperative, my lord.
Obviously, it's a coterie. That's what I'm telling you.
Not a coterie, my lord.
MSCC, there's a coterie in every
Sometimes he
court.
tries- he
There are
tries-
few people who do the matters for both sides. Insurance company panel,
No,
yes.
I'm not actually on behalf of the insurance company. Only for
No.
only for the petition.
That's then all the more you're a part of a coterie. No difficulty with. I don't have any problem with that, but you have to come prepared.
I'll come prepared, my lord. I'll come prepared.
Yes. Next.
Item number 40.
He's appearing, my lord.
All you will have to mark matters in which you are not appearing.
No, my lord. It's not like that.
It is exactly like that. But what is your prayer in this? And you are for the other side must
I'm
be.
ready for hearing, my lord.
He is not ready. আগে পুরো দাঁড়াও, পুরো হয়ে যাক, তারপর দুই হয়ে যাক, তারপর রেকর্ড করবো।
একটু দেখুন না আছে কিনা পেপারটা নেই না। My lord, I'm just finally submitting the paper book, my lord.
First see whether there is already copy.
No, it's not there.
I give a copy to him.
I'm giving. Just for the record. Right, a copy.
পুরোটা হয়ে যাক, তারপর রেকর্ড করবো।
কত নম্বর এটা 40 না
Listen, তোকে দেওয়া আছে। Listen, তোকে দেয়া আছে। And there, it's there, man. Already handed over.
There's already a copy.
Already.
You have a copy? Is it copy?
দিয়েছি, আগের দিন দিয়েছি। No, I will give it to you. I will give it to you. Kindly record it. I will give it to you. I have already handed over last occasion.
The paper book filed today be kept on record. On the prayer of the insurance company, with the matter stand adjourned till June 17, 2026.
17.
Yes, Mr. Borman is waiting for a long time, so he has to be heard also now.
Number 41, 42.
My lord, in item number 41, actually, this is Mr. Bowman's appeal.
And the other one is yours,
Yes,
obviously,
my lord.
yes.
No, no, my lord.
In 42,
So
there is a
in-
direction
in
upon.
40 actually, that has been filed out of time, my lord. 42. So I've already filed the CAN application. So.
That is appearing today.
No, no. CAN I have already filed it. Let them a direction, my lord,
What direction?
to serve the copy.
Can
of
is appearing today in the list?
No. It will appear.
Otherwise, there cannot be a direction unless it is appearing in the list.
I've already just today I have filed it.
So I'm adjourning it for the day.
Adjourn for the better.
Let them serve.
Yes, you can serve a copy in the meantime, unofficially. I'll record that on the next day. If they say that,
Lordship, lordship.
tell me that you have served because Mr. Borman
Lordship.
is already appearing.
I will serve it in person.
I'm not passing, I cannot pass in a direction unless it is appearing in the list.
Lordship.
It cannot be recorded in the portal.
Lordship. Just make it not today.
Not today, just not. If you record করতে
Can I copy this to have enough?
Mr. Chakraborty and Mr. Borman, you divide between yourselves.
He's appealing for other companies.
Acha.
Generally, he's appealing for nationalized companies.
Acha. And you are for?
Private.
Private.
Item number 43, item number 43.
Direction was given to sub copy to the.
At least a change of face. Yes.
The affidavit service is ready. I've already served the copy of paper book.
Nee, na? Dipankar.
The direction was given to.
Affidavit service file today be kept on record. Push-up.
Let the matter may be fixed on 18. Plan.
On the prayer of the appellant, the matter is adjourned till June 18, 2026. I'm not recording. Please just have your hand. They've already served on your client. Therefore, they are not recorded. Strictly speaking, you should pay for this copy. Whatever be the cost. 10 rupee, 5 rupee, whatever. Yes, next.
Item number 44.
This Shupra Singh is in Calcutta. Right. Her name is there, so we must be praying for time. Your other side is very happy with that. Not today then.
Item number 45.
And I'm for the opposite party claimant.
Maybe
There's a
not today.
direction to serve the file the paper book, but my lord, they did not file the paper book.
Oh.
On the last occasion,
None appears for the appellant at the time of call. Learned counsel for the respondent claimant submits that no paper book has yet been served on him. Push-up, the appellant is directed to immediately serve a copy of the paper book on the learned advocate for the respondent. Push-up, let the matter stand adjourned till June 15, 2026. Push-up, liberty is given to the learned advocate for the respondent to communicate the gist of this order to his counterpart for the appellant.
good,
Communicate the gist so that they give a copy.
extremely good,
And if they don't give still, then you can point out.
good.
So better to serve a website copy of this order.
I will serve.
ঠিকঠাক ঢোকো তাড়াহুড়ো করতে হবে না ঠিকঠাক ভুলভাল জায়গা না ঢুকে
Item number 46 with 47.
My lord, in item number 46, I filed the appeal. Actually, the first appeal filed before the 47. That is the appeal. I filed the counter appeal. Initially, appeal filed by the
Not
insurance
counter,
company.
separate.
separate appeal counter
Separate
appeal is
appeal.
something
Sorry,
yes.
Separate appeal file. If my lord, they file the paper book, matter can be heard.
LCR has,
Today or tomorrow.
LCR has probably not yet. We have taken.
LCR is come. my lord.
Notice for it. Oh, আচ্ছা, আচ্ছা।
এইমাত্র এলো তাহলে আর কি করে নোটিশ পাবে
Notice করে নিন।
Mr. Bowman, ask your junior to collect the notice from the office. Collect the copy because in any event they'll the 18 মাসের বছর principle will apply. So you ask your junior to take the.
Let there be direction to file paperwork. I will.
There is already a
There is
direction.
already- there is a
There is already a
direction.
direction.
My lord, let it be on the next week. They will, if they will. file
Right,
the
right,
paper
right,
book,
right.
that can be-
Since the
Good.
trial court records have recently arrived before this court, comma, in order to enable the appellant insurance company to prefer an appeal, to file paper books, let the matter stand adjourned till June 18, 2026.
Great, my lord.
I have adjourned till June 18th. If you can, you file the paper book in the meantime and give a copy to him also.
Great.
Thank you.
Item number 48.
My lord, I am on behalf of the appellant.
Hmm. Up to that, it's fine. Whether it's Mr. Borman or Mr. Chakraborty, that is the question.
I'm
Yes.
appealing, but the problem is that on the last occasion I have requested to supply the paper book.
You have not supplied, so you must suffer.
I supplied to
To
the
their-
office.
Hmm.
Office, my lord.
You never reach him.
My lord, my lord.
But you should take from your office, you inform from your office. I'm
My
keeping it
lord,
next.
Generally, the direction upon them to serve upon the,
And
since
you
you
have
are
won the
acting upon us.
accommodation, I
Serve and come back. I'll keep it on then.
Another copy I will.
Yes,
Great, thank you. I'll keep it on Monday then. And then till Monday করে দাও কিছু রেকর্ড করতে হবে। Not today সই করতে করতেই তো রাত খাবার হয়ে যাবে। Not today order সই করতে। ডাকো ডাকো ডাকো।
Item number 49.
Lordship, I am for the insurance company. For the
Now I have grown a habit of making it not today. Even if you want to do the matter, I'll pass a not today. So not today.
today,
Not today won't do. More than that.
problem is that we have already divided the amount. All the way. Necessary amount, everything.
So is it appearing in the list then?
Yep.
You have to move the appeal also.
But as per my knowledge, they have also filed a processing, but I have no number on them.
If they don't say that in court, then what can you do? You move your appeal now.
You say it is not there.
Do you have the paper book? Arriving.
Already. Lordship, can it be fixed on the 18th or next circuit as my lordship? It's ready.
I'm just adjourning for the week. Let us see. There are so many matters fixed next week. In any event, this will not be reached. Probably. If you do the other matters, this will not be. Just not this week. Don't record.
Item number 50.
Lordship, I have appealed, Lordship.
Yes.
Lordship, this matter is ready for hearing, my lord. Mr. Bhattacharya is there on the other side. So paper,
I have not-
paper book
not
is ready, my
received
lord.
any paper
actually.
book.
You not received any paper book?
Paper book is there. My lord, may I serve it?
Give a copy, yes. A copy of the paper book is handed over here and now to the learned advocate for the respondent. Push up. Next para. Let the matter stand adjourned till June 15, 2026.
Lordship, may I serve it?
The paper book is also filed in court, which is kept on record. Mr. Bhattacharya, will it be possible for you to come ready on Monday? I mean, you'll get this weekend.
Grateful, Lordship.
51 dako, 51 Mr. Shah. I think.
My lord, 51 and 52, my lord. Actually, Mr.
Pashupatinath
is appearing. So he's sick today. So
Next week I'm keeping it.
17th, my lord.
17th.
17th or 18th, my lord. 17th, actually, he told me that he will come on 17th.
Then 18th.
18th, Lordship. Grateful.
18th. Note karo.
Grateful, my lord.
Thank you.
Item number 53 with 54.
Your lordship, I'm praying for not today, your lordship.
What is Mr. Datto doing behind you? You are in this matter also?
Yes, in 54.
Oh, not in this matter. Why, ma'am? Start the matter. Start the hearing. What is the
I'm
matter?
not briefed, your lordship, the conducting advocate is not present due to some personal difficulty.
Who is the conducting admin?
Sir Sottom Sarkar.
Vipul Ranjan Bhattacharya.
Okay, kindly keep it on 7th.
17th. 17th keeping it would be useless because let us try our luck
16th.
tomorrow. No, why tomorrow?
Tomorrow I will be. 16th.
Second appeal then will never be heard because I doubt how many circuits, how many benches will take up second appeals for hearing. Who wants to delay the matter? You or them?
Because
Are you enjoying any interim order here? Do you know that?
she's enjoying.
I'm not aware, your lordship.
Then very well. But 16th. কি ক্যালকুট রেকর্ড আসেনি এখনো পর্যন্ত তাহলে হিয়ারিং এলো কি করে Yes, Calcutta records have not yet arrived. Why is it? সে উল্টো পাল্টা দিয়ে রেখেছি দেখো অ্যাপ্লিকেশন পেন্ডিং আছে মনে হচ্ছে এতগুলো ক্যান রয়েছে কিসের দেখো তো ক্যান গুলো কিসের
Can is for extension.
এক্সটেনশন এটা অ্যাপ্লিকেশন হেডিং এ দিয়ে দাও তো 16 তারিখ অ্যাপ্লিকেশন হেডিং এ দিয়ে দাও একটা অর্ডার কি রেকর্ড করতে হবে নাকি দিয়ে দিতে পারবে হ্যাঁ অ্যাপ্লিকেশন হেডিং এ দিয়ে দাও it will appear on 16th under the application heading because several applications are pending. It's not yet ready for hearing.
Not ready. I have filed the cross-examination, cross-appeal on the basis of their CAN application.
Oh,
appeal, memorandum appeal has not been sent.
she's not in the matter. That's the difficulty. Otherwise, I could have asked them what is the. I mean, they could have given a copy of the memo to you also. As you say 16th, then I'm keeping it on 16th under the heading application. Then please inform him. Yes.
Grateful.
Thank you.
Item number 55.
এটা রেডি ফর হিয়ারিং কিনা দেখো তো বুক আছে পেপার ইয়েতে রেকর্ডে জাস্ট নট টু রেকর্ড ঠিক আছে
Item number 56.
দেখে না ওদের
Item number 56 also.
নট টুডে
Grateful.
ওরা কোথায় আড্ডালিরা লাস্ট কল করে তারপর
57, Malad, I'm almost ready, Lordship. Kindly keep it on Wednesday. I will do the matter, Lord.
if you are almost ready, why Wednesday then do it tomorrow. Almost ready means
Not half ready, Lordship. Wednesday, I'll do the matter.
16th no use 16th if I hear it I won't be having time to decide it.
Still, Lordship. Because I'm willing to do
Tuesday 16th.
I'm asking for Wednesday. Lordship, can I keep it Tuesday?
Well, Tuesday 16th করে দাও thank you yes